I'm Brian Sullivan, the chair of the Harwich Board of Appeals. Welcome you all here tonight. Tonight, if anyone is going to speak, besides the applicant, and go to the podium to make a comment regarding any case we have tonight, there's a new procedure where there's a sign-in sheet on the podium. So basically, just to write your name down, so if you're going to speak at all on any case, again, besides the applicant and their attorneys, then it's just asking you your name and address to write that down for us, okay? So if you don't mind taking care of that as you speak, I appreciate it. Well, welcome to the meeting of the Harwich Board of Appeals on this date, March 29th. The purpose of this meeting is to hear and decide applications before the Board of Appeals which have been brought pursuant to the bylaw of the town of Harwich and the Massachusetts Zoning Enabling Act. As required by law, the town may audio or video record this meeting. Any person intending to either audio or video record this open session is required to inform the chair. During this meeting, the chair will recognize promptly a member of the board, the secretary, attorneys presenting a case, to inform the chair if a protocol is not being followed. So to start things off, I'd like to have the board members identify themselves, starting with John.
John August.
Chris Murphy.
Alexander Donahue.
Brian Sullivan.
Dave Ryer.
David Nunley.
Okay. Al, why don't you read our first case?
Case number 2022-31, William Little and Sandra Clemento Holtz. Through their attorney, Brian J. Hall, owners of the property at 10 Kings Road, Assessors Map 42, Parcel E 1-19 in RR zoning district. The applicant seeks a variance for a minimum lot size requirement for an accessory dwelling unit pursuant to the Harwich zoning bylaws 325-52 and Mass General Law, Chapter 40A, Section 10.
Thank you, Al.
Okay.
This first case is, we are reopening a public meeting for case number 2022-31, which was a continuance from the Harwich Board of Appeals meeting that held on November 30th, 2022. And I'd like to offer a motion to reopen the public meeting for this case. I'll make that motion. Can I have a second?
Wait, you need to designate who's going to vote.
I will in a minute.
Okay, well, even for the motion.
Okay. Okay, well, all right, maybe you're correct on the thing. I first have to indicate the fact that who's on the board here tonight that was at the meeting back in November. And that would be Al Donahue, myself, Dave Nunley, and Chris Murphy. Absent, we only had 5 members of the board at that meeting, and absent tonight from that meeting is Joe Beasley. We did a Mullen, excuse me here, as only 4 members of the board present tonight attended that meeting, I requested all the other members who wanted to participate meet the requirements of the Mullen Rule statute. I have affidavits from board member David Ryer, and this is a certification shall be part of the record of the hearing. Were executed prior to tonight's meeting and recorded with the town clerk. Attorney, well, do you need a copy of that, Mullen?
No, I'll take your word, Mr. Chairman.
Okay, well, I have it for you if you wanted it, okay? So, we have the affidavit. So that being the case, regarding this meeting, both voting and participation can only be amongst these 5 members. John needs to abstain from presentation tonight, okay? All right. So I'm not going to assign all 5 voting members, which will be Chris, Al, myself, Dave, and David Ryer. Okay, we're voting at tonight's meeting. At the November meeting as chair, I stated that because of opinions heard supporting why variance is warranted, I suggested the applicant request a continuance to allow time for the board to seek an opinion from town attorney. Attorney Wall had indicated in that meeting that he agreed and requested continuance for the purpose stated. I'm going to go over some information because we have records that need to be part of tonight's meeting. Okay, so just take a few minutes here, just take a second, and then we'll have you do your presentation again.
I certainly would agree to that, Mr. Chairman, but as a housekeeping matter, could I address the board?
Yes, absolutely.
So I am here tonight to continue to make the arguments for the variance that I made at the November 30th meeting. And as you might know, when this matter was continued for an opinion of town council, I also reevaluated the situation.
Correct.
And I made another request for relief for a special permit. I know the town attorney disagrees with me, but I'm prepared to make arguments about that tonight as well. However, I have found out very late-breaking information. You might all recall that the primary issue here is that my client is trying to get an ADU in an existing structure. The structure meets all dimensional requirements. He meets all the requirements for the ADU except for the area, the 20,000 square foot area. So that's the one issue that we have. And it's my understanding that this board, I think as recently as last night, voted to support an article at town meeting that would do away with that area requirement, which would render my case moot and would get my client the relief that or the goal that he's trying to achieve. So if that's the case, I think I'd like to ask for a further continuance to see if the town meeting passes that article, because that would render this case moot. And what I also don't want is to have a negative decision on the variance in the special permit, which would then trigger a 2-year prohibition, and then find out that town meeting passes the article. So for those reasons, I'd like to ask for a further continuance.
Okay. First of all, I will discuss this with the board, and I would be in favor of the continuance and so forth. Just to clarify things, it wasn't our board last night that met, it was the planning board
Okay.
that met.
Thank you.
And I spoke at that meeting, at the planning board meeting in support of the ADU new amendment. And I based that support on discussions here from our board discussions on, that was in favorable of having the changes done, particularly on square footage.
Okay.
Okay, so our board has supported that ADU amendment. I spoke at the planning board last night, and the planning board approved the amendment to have it go to its selectmen to be included on the town meeting articles.
Okay.
So, when town meeting meets, obviously, I think it's next month, I forget the exact date, then there'll be an opportunity for the town to vote and approve that amendment. At that point, after it's approved, it has to be reviewed by the state government,
Attorney General, yeah.
Attorney General's office, but I remain hopeful that new ADU amendment will pass, and particularly help you and help your client
Right.
on this case, okay?
I appreciate that.
So, we already have a continuance agreement signed by myself at the attorneys, and I believe we can do this continuance without any further paperwork.
Does it have an end date, though?
No, it does not,
Okay, absolutely.
okay? All right, so no, it was left at a future meeting. There was no end date.
Good.
So I'd like to make a motion that we can accept the attorney's request to continue the meeting. I have a second on that?
Second.
Case number 2022-31.
Wait, we need to vote on that.
Oh,
All those in favor?
aye.
Aye.
Aye. Okay, the continuous motion is passed.
Thank you very much for your cooperation, and we'll see you soon. We'll get back
All
to
right,
you.
Yeah,
thank you.
If the article passes, and I just read it quickly,
You don't need to come back.
I think he still will need a special permit. Under
Oh, no, excuse me, if the article passes, you still have to come back, and they'll be under a special
a
permit.
special permit.
The way the article reads, it allows lots with non-conforming lots. And you still have some setback issues on your lot, I recall.
I think the existing building meets all the dimensional requirements, front, side, and rear setbacks. It was just an area.
Okay, if that's the case,
Yeah.
and since if they pass a ruling to eliminate the square footage requirement, then I believe that probably means that you'll just be submit an application to the building inspector.
Right, we
Building
meet, we
commissioner.
meet all other requirements. It's
Then
solely
you
the
should be
area.
fine.
Yeah. So if that happens, then I would submit a withdrawal of the pending application.
Absolutely.
Okay.
Yeah. And if I require further relief, then I'll figure that out and I'll come back.
All right.
Luck.
Good luck.
Thank you very much, I really appreciate it.
Thank you.
Thank you. Okay, call the next case.
All right, case number 2023-03, John D. Baroni and Karen D. Gagny, care of their attorney, James C. Norcross. The owners of the property located at 14 Atlantic Street, Assessors Map 6B, parcel L140, in the RH2 zoning district. The applicant seeks a special permit to raise and replace a pre-existing non-conforming single-family dwelling pursuant to the zoning bylaws, Harwich zoning bylaws, 32554, Mass General Law, Chapter 40A, Section 10. This case as well has been continued from February 22 of 23.
Okay, thank you, Al. As in the last case, we only have 4 members of the board that were at the last meeting. Therefore, we use the Mullen statute for a 5th member. And I have an affidavit from John August that he has prepared himself listened to the meeting, and also read all materials. Do you need a copy of that Mullen statute?
I do not, Mr. Chairman.
Okay, all right. So, that being the case, just want to first review the fact that at the last meeting, voting on the case, here at the case was Al Donahue, myself, Dave Nunnally, and Dave Ryer. And so John August will be allowed to participate in the meeting. Chris Murphy was not at the meeting, so he will not be able to participate in the discussion or voting. Okay? All right? So I'd like to offer a motion to reopen the public meeting for case number 2023-03. I have a second? Okay. All those in favor?
Aye.
Aye.
Okay. All right. And as far as signing for voting tonight, it'd be our 5, Al Donahue, myself, Dave Nunnally, David Ryer, and John August. Okay. All right. So, I do realize from a most recent notice or information you sent us on new documents that you're looking at proposal to be inside the dimensions.
That's correct.
Okay. But I need to first, because of matter of public record, a lot of things transpired between the last meeting and now, and I need to go over that as a matter of public record,
Sure.
okay? So if I just take a couple minutes here to make sure we include all these documents. So at the November meeting, during the public meeting, it was the chair's opinion, as well as others on the board, that it was unclear if the board had the authority to issue a special permit to raise and replace a pre-existing non-conforming structure that encroaches on town land with a new structure that maintains the encroachment on town land. I suggested the applicant request a continuance to allow time for the board to seek an opinion from the town attorney. Attorney Norcross indicated that he agreed and requested continuance for the purpose stated. And the board unanimously approved. Before I request Attorney Norcross to introduce himself and continue his presentation, the applicant's request for obtaining a special permit, I just want to make part of the public record, the hearing relevant documents that received by the board prior to this meeting. So the request was out to town's attorney, Amy Keswell, for her opinion. And all the board members, as well as the applicant, I believe, have a copy of the town attorney's letter. So unless there are any objections, I just want to read the summary analysis. Is that okay with everyone?
Yes.
So Attorney Kiswell wrote the following. In my opinion, the board cannot issue a special permit that depicts an encroachment on town land without express written permission from the town. The existing encroachment is a trespass and constitutes an invasion of the town's interest in the exclusive possession of its land. Further, Atlantic Street is a public way that is subject to the use by the public and not one homeowner, and therefore, in my opinion, the existing encroachment cannot be maintained. Subsequent to that, there's a letter sent to Attorney Kiswell from the applicant's attorney, James Norcross, in which the following was written. I am representing clients who have filed an application to raise and rebuild an existing structure at 14 Atlantic Street in Harwich. The town building department recently forwarded to me your memorandum regarding the rather unique situation where a small section of the existing structure is within town layout. One item I did want to bring to your attention is that in 1997, the Harwich Zoning Board of Appeals granted to the then owner of the property a special permit to construct a new foundation underneath the existing structure. The site plan was done in 1995, shows the same encroachment as exists today, meaning that the house prior to the foundation was located within the road layout and the foundation was simply placed underneath. I'm wondering if this changes the analysis at all as to whether the town has previously approved this house situation. So, did you get the copy from Amy Kiswell today?
Yes, I was copied on her email.
Okay,
to
good.
you.
I thought
Yep,
you were, just to make sure that you had it.
I did, yes.
For the board members that may not have seen this, and you may not have it, you do have your records tonight. Okay, good, because it came late. So I just want to read for the record, in response to Attorney Norcross' question to Attorney Kiswell, she wrote as follows in an email today, on March 29th. Chair Sullivan, the below and attached information does not change my opinion that an encroachment cannot be permitted through a vote of the Zoning Board of Appeals. It is the law of this Commonwealth that a municipality may not be stopped from the proper enforcement of its zoning laws based on prior municipal decisions. And she indicates the decisions, in the state. Okay, which there were 3 listed here. The board has the right to change its mind. So basically, she's indicating that a decision that was made in the past, this board does not have to follow its lead. Okay, we're not obligated to it. So, I think at this time, I would request the attorney to introduce himself and those who are with you for presenting this case.
Sure. Good evening. My name is Jamie Norcross, attorney for John Barone and Karen Gagne, the owners of 14 Atlantic Street. With me again tonight is Jack Wishart, the architect for the property. Also here tonight is Joe Young, who would be handling the construction for Coastline, and John Barone in the back, who, again, is one of the owners of the property. And so as you heard, we received the town council memorandum and have submitted revised plans that pull the house back so that it's all located within our lot line and not within the town layout. So that has been filed with you for tonight's meeting.
Yes.
Additionally, when we were here last month, the neighbors to the back, the Griffins, expressed some concerns regarding I guess I call it the constructability of the building without encroaching onto their property. And so we submitted a construction protocol that outlines how the building is going to be built without having to encroach on the neighbor's property. Jack and Joe and their team went through that in a lot of detail in terms of how this all can be done from the Barone Gagne property. It includes, and Jack can go into more detail on that construction protocol if that'd be helpful.
It would be.
Okay, why don't we start with there, Jack, if you want to go through your construction protocol that you and Joe came up with.
So, I think the request from the board to present the build plan, the first thing that we wanted to do was protect the adjacent property. So we're gonna survey the boundary line, stake every 10 feet, run high-vis string between the stakes to clearly delineate that, provide temporary construction, fencing, with screening to prevent additional encroachment and accidental trespass. The septic can be completed from within the driveway at the existing location. Again, the foundation is to reuse the existing that is there and to use sonotubes with concrete grade beams, all of which could be completed, again, within the footprint behind that fence. We would then go and complete the first floor deck. Once that first floor deck was constructed, we'll begin constructing the north wall.
And the north wall is the wall that, just to clarify, is the closest to the abutters in the rear, is that right?
That's correct. Yep.
Thank you.
Yep. Painstakingly, every step, from the very inside to the very outside. Carefully, meticulously raised and tied off safely as possible. We have a 2x6 wall frame, 2x12 rafters and soffit, zip wall sheathing, and exterior installation now, which is new code. Installation of the windows, the siding, the exterior trim to complete the entire build-out. This is with tremendous challenge, of course, but this can be done. We intend to do it. Once we have the wall erected, fasten the ridge beam to a preset socket, a pocket rather, at which point the remainder of the exterior build would continue as appropriate. Pump staging, planks, etc., as a typical build would proceed. Setbacks be the same as they were, corner board to 1.08 at the rear, with an ornamental soffit extending slightly toward the property line, but not to encroach, which was a concern that we heard at the last meeting. And in terms of maintenance, we would be inclined to use narrow planks on posts and/or brackets set inside the property boundary, or, best case, work with abutters again in the future to see if there's another way for safe access.
Okay. Thank you.
So just to, I guess in general, Jack, then the plan is to build the north wall on the ground and then raise it
That's correct.
from within the boundary of the Barone-Gagnon property.
So you're building it like on the driveway there, or? where
On the first floor deck, actually, so then we could just stand it right up.
I see.
Yeah.
Stand up one floor at a time?
We'd actually probably balloon frame the whole thing and stand it all up together.
Excuse me, what does balloon frame mean?
Where the framing goes from the first floor all the way up through the second floor without a break in the plate in between the first floor and the second floor.
Okay.
And I think a final question issue that was raised at the last meeting from the neighbors was in terms of liability.
Yes, thank you.
Coastline has insurance, workers' comp, liability insurance to cover any sort of issues that may arise. But again, I think they've gone to painstaking detail to map out the build so that it's safe and that it can be conducted without encroaching onto the neighbor's property.
Okay.
I have a question with regard to the balloon. Sure. Is there any consideration to bringing in a crane to put that up?
Oh, yes, sir. If we feel like a crane can be employed and we're able to work with the highway department to close that portion of the roadway for a short portion, I think that would be ideal.
And when would this project,
This would be in the early to midwinter when this would be occurring for be like a day.
okay,
Day where it's not windy.
Yes, sir.
Yeah.
Yeah. And it will not be without effort.
Okay. You're doing your presentation?
Yeah, I think we presented the design at the last meeting, unless there's any additional questions on that. I think
Well, I
there were
think
just
there
a-
will be a few, so forth. One question I have is, how did you achieve on the frontage, have it not now be encroaching on town land?
So right now, that front 8-inch wall is a poured concrete foundation with a block cap. We're gonna demo that cap in the top portion, backfill with stone, and then pour another wall directly behind it, so that the new structure is fully behind the boundary. And
So- so
we're
you're-
abandoning in place so that we can avoid any structural issues with the adjacent roadway, any blowouts with having to excavate that.
All right, so currently, the foundation and the cap is encroaching. The cap itself is encroaching, but not the whole foundation?
It's the whole front of that foundation wall. Yep.
So you're just gonna basically
We're gonna take the top off.
take the top off, so everything that's left will be below grade?
That's correct.
Chris Nickerson from the Highway Department had a concern about your being in the right-of-way, and he attached a photo, and at the corner, the fence, he said, is approximately the town right-of-way. And now that you're coming right up to the property line, it looks to me like you're in the town right-of-way.
fence. On the front facing
On the front.
Atlantic
Do you
Street.
have the most recent?
I've got the plan, but I'm looking at the picture that Mr. Nickerson sent us of the fence. He said the fence is placed on what appears to be the town-owned road layout.
Oh, gotcha.
Oh, I see. Well, we will move the fence back as necessary.
Well, but I'm more concerned about the porch. Right now, you're putting it, well, I guess it was, but it's right up to the property line. So my question is that in the town road layout, or is it not?
It is not.
The foundation or the fence?
Everything, anything. Because
The-
you don't show the town road layout here if it goes, into the property, because the town does have easement rights back off of the road itself.
It doesn't have any rights outside the layout.
Well, but we don't know where the layout really is from the plan.
That's shown on the detail. You can see where it's
That
pulled
is the
out.
property line,
That's
right?
the property line, that's the road layout, extent of the road layout, the property line.
That's correct.
Okay.
See where I'm pointing on the right-hand side there? The fence doesn't go.
Yeah, I do. I'm just looking at Mr. Nickerson's note in the attached picture of the fence, which is about probably 2 feet from the road in, and he's saying that appears to be the road layout.
Well, and I think that's consistent with how the photo of the front of the house is as well, where it looks about 2 feet back from the road itself.
I think he was, not to put words in his mouth, I think he seemed more concerned with the fence on Pine Street, because that's right up on the road.
Well, unfortunately, he doesn't clarify, so
Yeah.
it could be. And I made that assumption last
So I've-
meeting, but
Yeah.
now that I looked at it again, it's not really clear, because the fence is on, well, it's on both Pine and then the diagonal there to take it over to Atlantic.
What I can offer is that all fencing will be taken outside the road layout and put onto the applicant's property.
Okay, well, I want to make sure the porch itself is within the town layout, too.
Well, the plan shows the porch
It's
outside.
outside of the town
Outside of
layout.
town layout, yep.
Okay, so what you're telling us is the detail now, the town road layout is on that line that shows you from .18 to .46 away.
That's right. So if we were dealing with the paved surface, we're not really we're close, but we're well beyond the paved surface. So the road layout extends past the paved surface, wider than the paved surface. And so that line designates the road layout that was taken by the town as opposed to the actual asphalt.
Okay. Okay, fair enough. Thank you.
Yeah, his other concern on that was also, that even though your house might eventually be even inside the, I'm just going to, with it right at the line, you know, the concern is from the town as well that when plowing's taking place and they're plowing the public street, as far as any problems regarding snow, you know, snow banks and so forth, you know, being a damage and making sure that the plows go by and keep everything on the street. Okay, so it's, I think Mr. Nickerson was very concerned about that, as well as that's why he presented that.
Sure.
that
And I think
information to
if you
staff.
look at the photo he attached, you can see the,
Right.
where the travel surfaces, there's a pretty decent buffer
Right,
between that.
so
and
it's,
where- Yeah. I mean, you'd have to miss by quite a bit, I guess, with the plow, but.
yeah, right, okay. All right, now, we'll go through the other questions by the board. John?
Yeah, I'm just not sure if there's any, you know, when you say below grade, what the town considers to be an acceptable level below grade, right? There's still gonna be concrete underneath.
That's
What is the town right away? How deep are you guys gonna go?
We would take it down to solid concrete, which, you know, it's like stone as far as roadway construction, I think would be helpful there. But it would be down to where the block was, which should be right a couple inches below grade.
Below grade?
Anything we'd have to grind down further, we will.
And saw cut?
Yeah, exactly. Yeah, what we don't want to do is have to rip the entire foundation
Yeah, the
apart.
integrity of it starts, yeah, but I think that would be the only question I would have, whether there's some sort of a desire to have that, you know, 10 inches below grade, 12 inches below grade, what, you know, is, you know, you don't want to have it 3 inches below grade and have someone come back later
yeah,
and
we
say
could-
it's not deep enough.
That's fair,
You
we
know.
could make it 12 inches.
But, or I could, you know, I might suggest if you wanted to attach a condition that it would be subject to the review and approval of the building department or the building commissioner in terms of how far below grade we have to go with that. I think that's something we could certainly.
I was gonna suggest that. if-
Yeah, let them decide kind of what they feel is acceptable on that. And we can comply.
Okay. Al?
No, I think we pretty well covered it. The only question I had was regarding the crane. I could see that could be a problem. I've had some experience, limited as it is, with cranes. And as long as that crane is supported properly, that road surface will not be damaged. However, I'd like to have a condition that should that crane, in some capacity, damage that road, that the town is protected.
Sure. We could include a provision that any damage caused to the roadway during construction is repaired by the applicant.
Dave?
To John's point, so some concrete is gonna still remain in the town road, is what you're saying?
Underground.
Underground.
Okay, but we can't, our town council said we cannot issue a special permit letting them keep their structure, whether it's below ground or not, in the town property. She told us we don't have that authority.
I think, all right, I see your point. I believe, and let me just go back to what the attorney wrote. And I think it had to be as far as placing the new structure would have to be within their lot. So if the new structure is being built at or inside their lot line, I do believe that is meeting what the attorney, town attorney said. Because if they're not building back, if they're not building back on the current foundation, which is inside which is an encroachment, and they're putting up new tubes, correct? Or how are you handling the front foundation?
From the inside, sir,
Excuse me?
from the inside.
You're pouring a new front wall, is that correct?
Yep, inside the existing foundation.
You're pouring a new front wall.
Correct.
So if they're pouring a new front wall inside their lot, doesn't that meet what the,
I don't think so, because we're permitting them to keep the obstruction into the town property. It's underground now, it's gonna be below surface, but it's still there, and it's still their property. When
Not
town
really, it's the
council says we-
town's, the town's property. It'll still be the town's.
Well, I mean, but
It'll
that's
be
why
connected.
this whole case is here hung
Yeah.
up.
I mean, you could certainly excavate it out. It just seems like a lot of work for no real purpose. And I understand the position from town council. That being said, the zoning board did approve the foundation in the first place, so then say you gotta rip it all out.
Well, they approved, they approved the foundation in error, because they did not have the right to approve that foundation, because it was on town property.
No, I understand. That's just sort of
That's
a
what the-
fairness argument, I guess.
Right, no, I
It's a-
realize that. Unfortunately, many cases are coming before us where we love to be emotionally or fair, common sense,
Yeah,
but doesn't necessarily mean the town's code
right.
that's written, we have to go by, we may not think it's common sense at that particular time, okay?
Is it-
So, if I go back to what the attorney said,
It would be.
she says here the last words were, "Further, Atlantic Street is a public way that is subject to the use by the public, and not one homeowner. And therefore, in my opinion, the existing encroachment cannot be maintained." And what you
That's my
refer,
point.
what your point is that keeping that foundation there can't be maintained.
It's an existing encroachment that they would then maintain, and we would have approved it, like what they did in 97, by issuing a special permit. My personal feeling is what you need to do is have a meeting with our town manager and go to the Board of Selectmen and get them to, okay, you're leaving that below-grade concrete in. That would, I think, be your easiest remedy, rather than immediately, trying to take it all out. If the Board of Selectmen, I believe she said, if they sign off on it, then that's okay.
Well, David, your point here is that the existing encroachment cannot be maintained. Those words are saying the fact that
Yeah,
the town would be seeking to have it eliminated.
Right.
Have removed.
right. And because I think that's what town council is telling us.
I agree with the process. I would hope that the answer would be, it's all cut down to a certain level and leave the rest. 'cause I
Yeah, it's
don't-
not,
I
it's
don't
not
think they want
affecting
a huge-
anything, but.
Well, I don't think anybody wants a huge
It's-
excavation there, but
And while I think your position makes eminently good sense,
Yes.
I don't think it's passes the legal muster. Okay, it's good practical sense, I agree, and that's why you might want to meet with the town manager and see if he can get the selectmen to agree that it's okay to leave that encroachment under the road. That's-
Or you eliminate the full foundation in the front.
Well, no, because they'd have to take out the encroachment in order for us
Well,
to.
well,
Or that'd be
approve it.
eliminating the foundation in the front.
That's what I'm saying, they eliminate they eliminate the current foundation on the front of the
Oh,
property.
yeah, they have to remove it,
Remove it.
right. But I would go, I mean, you can do what you want, but
Sure. Well, I think in terms of moving forward, if perhaps, again, you wanted to condition that they had to be removed, and in the meantime, we can have a discussion with the town manager and Board of Selectmen, and perhaps come back with if they're
I just
agreeable.
don't see how we can grant a special permit.
On a technicality, I think it's best that there's a continuance.
Well, I mean, I don't see why we need to continue, because it's, I mean, you could grant the special permit saying you need to remove the foundation entirely from town layout. And then we can have a discussion in the meantime, as opposed to a delay.
Or seek the approval of the selectmen's.
I just think in terms of moving it forward, that makes more sense, and then we can see what we can achieve in the meantime with the powers that be with the town, because otherwise then we continue in a month, it's not necessarily easy to get a meeting right away, and then at least there is a path forward, and if my clients decide they're just gonna excavate it, they'll excavate it, but in the meantime, if we can come up with a resolution with the town, then perhaps that would be achievable.
Before going forward, and we have to open up the meeting to anybody that wants to speak regarding this, we were in receipt, in addition to the abutter who had sent in a a negative opinion of going forward. We did receive another, not immediate butter, but some in the neighborhood, sent a letter in, I don't know if you saw it, from Jamie Goodwin. Okay,
No, I didn't see that on the online portal.
okay. It just arrived, and basically regarding the zoning board of appeals application, this is on Atlantic Street, please note that I oppose the plan submitted as it builds outside the footprint of the present building. So that's, you're working towards addressing that. As a long-term resident of the campground, I and others have been told many times that you must stay within the existing footprint with respect to the square footage, with any new home construction. And the rest of the comment comes into, that discussion about the footprint. And the request of the Board of Appeals to remain consistent with past actions and reject the application. But if your building, the new structure ends up being inside the lot, which you've shown in your plans, then it meets her objections that she stated here.
Just to
Okay.
confirm it came from Peter Chalakis.
Yeah,
that
Peter
was-
Chalakis, yeah.
It was
Excuse me,
sent-
I'm sorry, Peter Chalk.
No, it's
Thank you.
confusing the way it's printed
Yes,
here, but
thank you very much.
I
I apologize.
I'm just gonna comment, I appreciate their position, but it's incorrect. There's no requirement that a new structure go into the existing footprint of the building.
No,
And we've never required that as a board, and that's not the legal standard. So, they're entitled to make their comment, but it's not legally correct, so.
okay, you would, any other questions from board members? Is there anyone in the public who'd like to speak to this matter that's here tonight? Yes? And could you sign in and also identify yourself?
Yes.
Thank you.
Thank you. Dan Griffin, 10 Pine Street. I'm a director butter behind the property. I've been following through at the past meetings. First of all, I'd just like to say at the past meeting, it was kind of recommended that we'd move forward. There was a couple concerns. The town had the concern with the front and the setback of the street, which you've addressed. And we had concerns of other issues as a butter with the with different, setback encroachments and issues that we were, starting to talk about. It was recommended that they speak to us or we get further information. So we came back to this thing. I never received anything on the constructability. I haven't seen any new drawings, so, and then I was listening today, so I understand the parameters that you're going about in the front. Don't really have a problem with it, if whatever the town decides as far as the home, if we can get back to that, that line, we're not amicable to that, but what we really need to see though, because to determine anything, you need to know, so there's no new drawings, so the house is, I'm assuming is the same as it was on the second rendition. And on the second rendition, the house is a 40-foot structure. The property itself is 40 feet. They said it keeps the same setbacks that was on the original drawing. That's mathematically impossible because the building originally was 6 inches into the town. So at a minimum, there should be a set of drawings, set, not a verbal that we're gonna move it. There's some other things that are issued. I don't think we're close at all to making any type of a decision here. I'm not a board member, but I have a lot of other things that weren't necessarily touched upon because we were just at the beginning of the process. So if the design is still the same as because that has to do with constructability also, where, how much room you have and where it is. But along with that, I'd like to make an attempt to clear the air on some of the written and verbal discussions that have been made and that have been documented with regards to this petition. I've been at each one of the public hearings so far. And in lieu of discussing constructability issues, I feel we should be addressing the non-constructability parameters. I have two main talking points, and the first is with regards to the documentation. You know, there's been written documentation and verbal documentation that states that the applicants are proposing to raise and replace the existing dwelling and will not be increasing any of the setback nonconformances. This is not an accurate written statement. It's been written and it's been spoken verbally. It's not accurate. The proposed house is not located on the same footprint as the existing structure. The proposed house will increase the nonconformity and add additional unreasonable encroachment on the already non-conforming setback. As an example, for the drawings, and they don't really show it terrifically on all the documents that have been shown so far, but the house itself, they allude to, we're going to square off a little section of the building. Well, what they actually want to do is they want to take a corner of the house that's already non-conforming, extend that non-conformance all the way to the end of the property line. They want to come out 5 more feet, and they want to come out a total of another 13 feet to the left. So the first floor footprint of the house, which is actually the habitable square footage of the existing house right now on the first floor is 680 square feet. The entire first floor square footage that is habitable on this house right now is 680 feet. So that is the footprint, so to speak. They want to add another 65 feet that's outside the house, and they want to essentially keep it the same but just square it off. In squaring it off, they're driving the back of that house from a 5-foot setback that's already non-conforming, not even close to the 20, and they want to drive it back all the way. And if the design hasn't changed, then that 40-foot house, it's a 39-foot house with 6-inch soffits mirrored on each end. That's 40 feet. The property is 40 feet. There is not 1/8 of an inch on the front or the back. But regardless of that, you know, the attorney specifically wrote in a letter, and if you reference the KP Law letter, that in order to even apply for a special permit, there are certain things that are required by law, and the board has to, you know, is subject to review them and try to hold them up by law. As a direct abutter, these are my rights. No, you don't have the right with zoning to take away a complete setback and build something right up to the end. And per zoning bylaw 325-54-5, she specifically states that if you reference number C, the replacement structure will not increase any of the following existing non-conformances: building coverage, site coverage, or setback encroachment. There's a 65-foot blatant setback encroachment on the design drawings as they stand right now, and it increases an already existing non-conformant setback. So you're going from a 5-foot setback that's not even, they're tight, they're all non-conforming houses down there, but you're taking that 5-foot setback that's supposed to be 20 and you're making it nothing, taking it right to the property line. Never mind, you know, talking about constructability, it's just unreasonable, and I believe it's not legal. Second, with regards to the habitable square footage of the existing building, the existing building presently right now consists of a first floor, which is 500, consists of an existing first floor that has 575 square foot habitable. The existing building right now has 575 foot of habitable square footage on the first floor. The second floor of the existing building right now, and there's pictures in that were submitted in the things of the house, because it is a little small house. Second floor has 228 square foot habitable. So existing house right now has a total habitable square footage of 803 square feet. The basement is a non-habitable space. It was added on as a storage, a basement storage area, no access other than a bulkhead, and it's 720 square feet, but of non-habitable space. If you reference the other section, A, B, C, D, from the town attorney, she said, if you're going for a special permit, a replacement structure may not increase the habitable square footage of a structure by more than 25% over the habitable square footage of an existing structure over a 10-year period from the date if you allow a special permit. So the house right now is 803 square feet, and the latest proposal, the new home has habitable square footage of 2,080 square feet.
If I could just stop for a moment, and I think you've raised several good points.
Yeah.
Which are, in reading the bylaws, the town's bylaws, as you read them, would lead one to feel that there are several areas why this board could not approve this application.
Yeah.
Now, since the zoning code was written and it hasn't been updated, okay, there have been state land court cases, one particular called the Gale case, which basically has made those zoning regulations of this town, it overrides them. And the town's code has not been updated to to be in line with court decisions. Now, that's a process the town knows it needs to do, and that process is going to be taking place, I believe, at some point over the next year, whatever, but the town's aware of that. So there's a thing called Gale case, and basically, how the Gale case, in summary, we look at a proposed project, if it will intensify one or more existing nonconformities. And as long as something is not substantially more detrimental to the neighborhood than the existing structure. So they look at the Gale case looks at the structure and says that you don't really substantially change in the structure, you know, it doesn't matter about how you adjust your habitable space inside, except when it comes down to like health department codes and so forth, number of bedrooms and septic and so forth.
Right.
So it is confusing, and as you've spent time going over through the codes, and when I initially saw this case, I looked at, right away, I looked at the habitable square footage being, almost doubled. I mean, substantially higher, okay? Far more than the 25% that the town code says.
Right.
Per land court decisions, such as the Gale case, that doesn't matter anymore. It matters what
And I was
matters.
kind of making points, but it was also referencing the town attorney that put that in writing in your documentation.
I didn't see the
Right, and the
attorney
K-
responded to this case.
KP Law, she responded, if you read the beginning part of it, she listed it as a requirement.
And let me go
What-
back to that, and I
what-
didn't read it the same way you did, sir, so. Oh, no. She's referring to, she actually wrote the town code as required,
Yep.
okay? It's up to the board to apply,
Right,
land court laws that have been enacted
right,
since this code's been written.
right.
And so that's why we have a Board of Appeals.
Yes.
So even though what she wrote here, and she did not refer to the Gale case, that's our job.
Right.
Okay, she did her job on showing the town code, but on regarding that 25%,
Right.
based upon the Gale case, the applicant, if they're not, they can intensify a nonconformity, and in this particular case, if they're not, and I don't believe the setbacks are really, in some regards here, being improved.
No, no,
Yeah,
So,
they are, okay? But, and this is up to the board, this board here to decide tonight
Right.
regarding how we apply the Gale case.
so I mean, I'm not.
I just want you to try
Yeah,
to explain to you.
I appreciate that, and actually, I'm the same, like, I've spoke before, I'm not trying to be pervert and not have them make it, but I have to, make certain points.
Sure,
'cause-
absolutely. I
'cause
appreciate
they're going, they make statements before, like, oh, we've done we've made, we went from version 1 to version 2 and tried to keep everything. The scale from version 1 to version 2, the square footage of the house went up. From version 1 to version 2, went from a gambrel to a straight gable roof with double dormers, more square, more like a row house. Originally, it was gambrel to match the neighborhood, but even with all of that, it's really about the size and mass of the house. And in the area that they're going back on the back, that's our major concern. I'm not unreceptive to whatever the owner, our new neighbor can work out with the town for that front, because that's a tough situation. I don't think, if you can get it on the edge and the town's all set, that we have no problem with that. But when you come to the back, the areas, the size of the houses, the size of the lot, the areas of setback, the house right in front of us is 5 foot back. Their house was 5 foot back, and then they added this little 5x7 room that looked like it might have been a shower at one point. Somewhere along the line, they stick a foundation under it. Now they want to square the thing off and take the entire property, and they're increasing the non-conforming setback that's existing right now. There's no building in that corner of it's a deck, and then the house steps back. So they're already gonna build the house twice as big upstairs, but I understand in buying beautiful property there, and the owner, he needs to get it nicer and better square footage, but everything they've done so far is to totally maximize every little inch that you can. If they can, hold that setback, and then, maybe something where, I'd be more amicable. In the building of it, I've been in the trades for 35 years. I didn't see your plan, but it was like, that was the biggest 101 thing I've ever seen. I'll put a safety fence, I'll monitor this. Even if you frame and build it standing up, you're gonna you're gonna have it all shingled, finished, windows trimmed. You are, and you're gonna stand it up done. And then when you're gonna come in, and you have to paint or change the screen, and you literally, right now, the house is designed on the property.
Excuse me, sir, excuse me.
Yeah, but I think it's unreasonable.
I don't want any other comments coming from anybody, excuse me. I don't want any other comments coming from anybody, even associated with the applicant, unless you're called upon. Okay? Now I'm gonna ask the attorney to respond to the comments that the speaker has indicated. And at that time, you can address, any of his concerns, okay? But do not interrupt him.
Thank you. Because you can always say, everything can be done. I can build this, I can do that, but I've been in the trades for 40 years. It's not standard practical. I can't even think of a property that is all built both sides on the property line. No setback either side. So I oppose that. I think it creates a density, an excessive size building for the lot. There's all the factors that are intrinsic that, I'm not trying to be that way, but I think so. But that, if the 125%, if it's really only 800 and that only takes you 1,000 square feet, I wouldn't stand here and say that the new owner is minimum to 1,000 square feet, but he's away, you could easily not take that 5-foot encroachment, still build a 32 by 30 house. You have a 1,800 square foot house. It's gonna be tasteful, it's gonna be functional, it's gonna be worth it, worth his effort and be a good neighbor. But to jam everything back, and then I said before, like, he mentioned that, I said before about it, like, we were more concerned, with some of the side stuff, and he's there like, oh, your view's not pituitary or something like that, and they added, which they didn't have on the first condition, they added some entrances on the side, landings, you know, even when you put, you only have on the, I don't know the new design, but if you have a landing and you got the street now, there's setbacks for landings, you have a new septic that isn't designed yet. From what I read, I'm not an attorney, and I've only been reading the documents and not trying to be a totally prohibitive neighbor, but there, I think if you have certain things that should be adhered to conform to the neighborhood. And the septic itself, when I read earlier, it seemed to me like when I first read it, I'm not an attorney, but we shouldn't even be an application in for this property. Because this property right now, according to what the Board of Health said, it says you can't even put a permit in, you can't modify it, you can't add anything to it. Because right now, there's a variance on it, and it has to be settled and eliminated before you can even move forward, because 20 years ago, they didn't update the septic, so the owner put a condition on the house saying that this house will never be added to 1 square foot, and it's documented, and the Board of Health Director stated it, so she's there like, I don't see how you can even put a permit for this house. I'm not trying to say that the owner shouldn't put a permit in, start the process, get the thing moving so you can build in the fall. But we're jumping ahead here, talking about how walls are gonna go up with cranes. When you're encroaching right to my property line, you got a septic system that was non-conforming, and you got a condition of the town saying that you can't even apply to do anything to the house, can't add 1 square foot, and the Board of Health said, first thing you should do is go and get that waived. Then once you get it waived and you have your new design, what are the setbacks to the septic to the house? There's some, you know, when I've built projects, you have setbacks from your septic system to the house. So I think there's a lot of moving parts here, more than just ramming this through.
Thank you, sir. I appreciate it. Now,
May we respond, Mr. Chairman?
yes, in a minute. Just so you know, the Board of Health, they've indicated the fact that they had reviewed the application for a special permit to change the use. Excuse me, I'm sorry, got the wrong one, I apologize. The Board of Health will require the applicant to meet all septic design requirements for that site, its size, number of bedrooms, et cetera. That will happen, but attorney, please,
Thank you, Mr. Chairman. To begin with, I think you touched on the law that was brought forward by Mr. Griffin in terms of an incorrect reading. We're pre-existing non-conforming, we're entitled to expand non-conformities. We're pre-existing non-conformity under the case law.
Can you set them up there? Sorry. I just couldn't hear.
yes, could you repeat that, please?
That you correctly recited the law of the Commonwealth, where pre-existing non-conforming, we're allowed to increase non-conformities when we're pre-existing non-conformity under the case law in the Commonwealth. So to say we can't go over 25% or we can't go closer to a setback is just not correct.
Yes.
I'd be remiss in not pointing out that after the last hearing, at the advice of the board, my client emailed the Griffins within days asking to have a meeting to discuss the project and see what we could do to satisfy their concerns. I sent a follow-up email after he never got a response, my client. I never got a response. So instead, the neighbors show up today, which is their right, for sure, and address their concerns. We could have had this conversation weeks ago. We tried to have this conversation weeks ago when we never got a response to those emails. I would just like to point that out to this board.
Okay, thank you.
In terms of the rear setback, it's currently 0.77. We're going to be 1.2. Is there more house back there? Yes, it's getting squared off. But it's not closer to the lot line. That's just an incorrect statement. It's a bigger house. That's correct. It's a small lot. It's not gonna be a big house by any stretch of the imagination. In terms of massing, we could go as high as 48.26 for building height. Our proposed is 43.88, almost 4.5 feet less than allowed under the zoning bylaw. So we're not maxing out the height in terms of massing. One of the Griffin's concerns at the initial historical meeting was the height. We reduced it by 10.5 inches at a request from them and from the historical commission. So we already brought it down 10.5 inches, and we're 4.5 feet less than the maximum building height allowed. So we're not maxing out height. We're cognizant of that. We're leaving the area of the driveway and the septic open. That's the main view corridor for the Griffins to Nantucket Sound. In terms of massing, while we are close to the rear property line, we have to be at least 50 feet from their house. So were we to bring it 2 feet reduce the size by 2 feet, 2 feet over the course of 50 feet, you're not gonna notice that difference. It's not gonna make a change in the visual character of the property at all. And I do not think it's in any way substantially more detrimental to the neighborhood. We are going bigger, but it's tasteful. It's a small lot, it's a challenging lot, but we're working within the setbacks that already exist as best we can, and I don't think it's in any way substantially more detrimental to the neighborhood.
I accept and agree with most of your points here. One thing you mentioned was you have to be 50 feet from the next house?
No, I'm saying we are, look, just from
Okay.
50 feet from where their house is.
Okay.
I would estimate.
Thank you. I thought you said this was a requirement.
No requirement. They
Okay,
could certainly
thank
go
you.
closer, but
You
that's,
said that, I was a little confused.
Nope.
I guess I just want to be clear on the total length of the property is, for the new site plan, we shortened it. It had been 39 feet, that was correct. Especially where we were going over into the roadway at the front. So now it's shorter and total length at 38 feet, 4 inches plus minus.
And just to clarify one other point, we have to submit an as-built when this is constructed. So if it doesn't match what's on the site plan, Jack and his company are in a lot of trouble.
A lot of trouble.
So it's not as if this is gonna get built and somehow mysteriously we're gonna miss by a foot. I mean, whatever's shown on the site plan is gonna control the size of that building in terms of where it's located on the lot, just so the board understands that piece.
Ms. Griffin, you had your hand up. Would you like to speak in?
Is that what you have to do?
Yes, sir. You need to go to the podium.
I just wanted to, just as a rebuttal, I mean, because there's a lot of hearsay here. Where did you email it to? What email?
The same email I sent the plans to for
Right,
historical.
so I never received any email, or never received any plans. And if and verbally now, I'm hearing that they've changed the size of the building. There should be new plans. You just say, I'm changing the building, we got these setbacks. You have to see the math in the drawing. And even with all of that, we're talking about the square footage, but the increasing the encroachment is an issue.
Yes.
Just to clarify, under the existing law, and it wasn't the land court, it was the Massachusetts Court of Appeals,
Okay, thank
fairly authoritative, but that's okay, because I had to go look myself, I didn't remember. The current law is they are entitled to increase the nonconformity as long as there will be no substantial detriment to the neighborhood, not just to a neighbor, to the whole neighborhood. Okay, that's the legal test, and that's what this board is operating under. Square footage doesn't really matter unless it's to the extent that it's gonna have a substantial negative effect on the entire neighborhood. So I understand your points, but they're not real, let me finish though.
Yep.
They're not really germane to the legal issue.
So
Okay.
why do they have I'm not being a wise guy, but why are there setbacks and why is there encroachment? And there's a nonconformity when you're within, your bylaw tells you have an X amount of stuff, but then you can be nonconformant. But once you're nonconformant, you're saying now there's no, you can keep going nonconformant as much as you want?
Unless there's a substantial detrimental effect to the neighborhood.
so there's
That's the
any-
legal, that's the current legal standard.
One qualification that
Now,
is.
you might not agree, you might not like it, and that's your right, but that is the standard that this board is operating under, and all boards of appeals.
I think in simplicity, at one point, there were one set of zoning regulations in town.
Right.
Then the town changed it where, not all the town, but a major portion of town is now 40,000 square feet with setbacks at 20 feet and 25. So any house that's in that zoning district that requires now 40,000 square feet to build a new, a Form A lot, a new house, if you're only at 12,000 feet or 8,000 feet or 39.5, your house is considered non-conforming, that lot. And should one of your setbacks be under the guidelines of 25 feet and 20, based upon the, side and frontage and so forth, then that particular setback is considered non-conforming. So that's where it comes in. The houses in your neighborhood, well, they're all non-conforming lots based upon the new zoning regulations and codes. So it isn't the fact that somebody put up a deck and made it non-conforming, okay? It was that area, because the zoning codes in the town of Howard's changed, and now it changed to, like in that zoning district, 40,000 square feet for a minimum lot size for a new construction, then everybody is a non-conforming lot in that area. So,
Well, I have to on record that it's totally unreasonable to take away a complete setback and have no setback whatsoever and maximize the house and then, try to come up with a proposal that you're gonna build it and be able to build it with no space.
sure, Mr.
Thank you.
Griffin, I understand your points, but I just want to make one final one that, my pleasure. As just one board member here, looking at the current setbacks that are being proposed for the new building, basically, they've, in general, have improved the situation. Your rear setback, which was just inches, is now at least a foot or more, okay? It is based upon, the application here. They're fixing the front situation. The side setbacks haven't changed. And unless I'm reading it wrong, I just want to kind of point this out. The issue that you're pointing out is that the building is getting higher, but it's still within the requirements of the town, okay? And I just want to, so the attorney across was correct when he pointed out these setback situations do meet the guidelines, of the town, okay? One last point, and then we're gonna call it into it.
So when the setbacks that you say that you're making it better is because there was a deck. It's not a house. the
I know, I
deck,
realize that, but it is property, it is construction on that site.
That wasn't proper.
Right, and they can,
It was
based upon rights, as we understand, now the board has to make this decision. I'm just talking individually here.
Because the deck was put in after the septic system, you can't.
The deck was approved by the town.
There was no permit on it,
Right.
because I looked it up. So the deck wasn't approved by the town.
Okay, sir, not to cut it off, but none of that is germane to what,
Well, it is if you're taking
no,
that
it's
as a
not.
basis of an existing setback, and saying that
That's
they're not reducing the
that's
setback.
history. Right now, we need to look at this plan.
You can look at it, but I wanted to make sure that.
They are entitled to increase existing nonconformities right up to the edge of their property as long as there's then gonna be no significant detriment to the entire neighborhood.
that-
That's the current legal standard.
Yeah, well, I think the legal also says that conformity about a building, not a structure or a deck. A building,
Okay,
Okay, that's it.
you know.
I'm gonna move to close the public hearing, because do you have anything new to add? Okay,
Okay, Mrs. Griffin,
all right,
go
then
ahead.
I'll withdraw my motion.
I would like to,
Just, could you
Comment.
speak a little louder,
sorry,
please?
I'd like to comment on the attorney's condescending that we didn't reply to emails. I don't appreciate that. We didn't get them. If we did or didn't get them, we have the right to come here and maybe not talk to you. So that's really insulting. We didn't get them. Our point is, they're gonna extend their house by 12 feet, 1 foot from our property line. How is that gonna be built? I just don't see it. But I wanna make it clear, how in perpetuity can they maintain it and not encroach and trespass on our property? That's all, I just wanna make that point. There is no exception, there is no workability, because I've already talked to an attorney. And if we need to put it in writing, attorney, we will. You're not gonna max a house on a lot at my expense, working from my lot, today or in 100 years. I think it's very unreasonable and very selfish. Thank you.
Thank you.
Appreciate you giving me a second.
Ms. Griffin, would you mind just signing the paper?
did.
Oh, thank you.
I'm gonna move to close the public hearing.
Second.
All those in favor?
Aye.
All right, now discussion. One question I have is that obviously in the building frontage has been changed as far as they're moving it back a foot or so, I mean, as far as the structure, to be inside the lot, a few inches, to be inside the lot line. Sometimes in cases, we have, when there's been changes in the design of the building, we have requested applicants to resubmit plans. In this particular case, my initial feeling is the fact that it's a minor adjustment, and I'm gonna ask a question, nothing's changing on the site itself and the frontage, on design and so forth.
No change to the elevation, sir, no?
Elevations, the design of the building is not changing,
Correct.
window locations, nothing.
That's correct.
So the design itself is still the same. So even though it's a minor adjustment in, 2x4 or so,
Right,
I'm not
they do
inclined- I'm
do
not
show it
inclined-
on this plan.
huh?
They do show it on this plan, the
clear-
new plan.
I think
Well,
to
they
clarify
show the
your point,
location.
Yeah.
Are you losing the space from the deck?
Yes,
Is
sir.
that where you're taking it out?
The porch is shrinking.
The porch is shrinking, and I don't believe we need to entertain a new set of plans for that minor change.
No.
Okay. Does anyone else on the board have any comments or questions want to make?
I still don't think we can approve a special permit, given the opinion of council we have, and I don't think we can handle it with a condition.
Even if the condition is that they remove,
I'm sorry, I think
Condition
either
Would that be-
they're gonna get permission from the town to leave it there, or they're gonna have to remove it.
No, if you condition it that we have to remove it, that's fine.
because then
That's no different than us coming in with a plan today saying we're gonna remove it.
But then we're approving it in the meantime, which
But we can't get
town
it,
council says we cannot do by issuing a special permit with it in the ground there currently.
Right.
That's my position.
but
With it
alternatively,
shown.
excuse me, Jack, alternatively, we'd have to go in and dig it out ahead of time and then come back to you, which doesn't make any sense.
I don't.
The building, I think if you condition it, we can't get a building permit to move forward unless we satisfy that condition.
I started with the question, so I don't think the plan as submitted speaks to how far below ground, it just says it's moving. So I think if we say the condition is the entire thing moves,
then
And-
we meet the lawyers.
then if they can somehow ameliorate that with the town afterwards, but, 'cause again, the drawing as submitted does not say there's anything subgrade, it says it's gone.
I'm gonna vote against it, but that's just my position.
Because of that issue,
Yes.
I just don't understand how we correct that.
No, I understand that, but things get overlooked. And if the porch gets built before it comes out, nobody's gonna know, and 5 years from now, they're gonna come back and say, we approved the plans like they did in 97, so.
But, I'm sorry to interrupt, but unless we go in now and demo the foundation, I don't see how we sasatisfy your concern. Because it's always going to, it exists today,
Well,
right?
you can go to the town and get permission to leave it there.
But we're saying we're saying we're not gonna require that, we'll remove it. So I don't see why that would be an issue, if we're saying there's gonna be nothing left on the property. On the town property.
My personal view is that it should not be handled through a condition. Take it out, let them come back.
But then we can't take it out.
You can't take it out without demolishing the house first.
Let's go back, let's continue it for a month and go back to town council.
I appreciate the concern, I just don't know how to address it other than saying we'll take the entire foundation out and get it off the property. That's what the town council asked us to do, that's what we're saying we'll do. That would be the process. You know, we can't demo the house without having a permit in place, because then you lose the grandfathered status of property. So we're not trying to pull a fast one with you, Mr. Ryer.
No, I'm not,
And if you want, however you want to paper it up to make sure you're
I'm not
comfortable it's
worried
gonna
about that,
happen.
I'm just worried about it getting,
Well, it's a condition, it's very specific, it's just like you can't do work between such and such a date, I mean, it has to get followed, that's part of the zoning decision.
Well, I don't know, what do you
If-
guys
I
think?
mean-
Let's hear from somebody else on the board.
John?
I think the condition that it be removed would satisfy that concern.
I agree with that.
I would agree.
Okay.
No, I mean, I would agree the fact that if we condition that the foundation in the front of the house, and is all the foundation currently in the front of the house encroaching?
You mean the entire width?
No,
Yeah.
it's just the front right portion. If you look at the plan, you can
So-
see how the,
Well, that's not
No,
exactly,
no, the entire piece is.
it's not exactly
Okay.
true. It looks
So-
like the whole thing there.
All right,
You're
so
correct,
well,
Mr. Ryer, yeah, it's .14 to,
I think it's very,
that's all right.
I believe that we condition the fact that the foundation on the frontage is required to be removed.
Right, so none of it remains in Atlantic Street,
None of it.
none of it.
Now, in removing that, obviously, you'd be demolishing the house and removing the foundation. That process obviously would still have to be under the approval, how it's handled by the building inspector, make sure that it's done properly and how you handle the street. But I don't think that's gonna be a concern of his, as long as it's done professionally and so
No, I
on.
wouldn't think so.
I think if we condition the removal of the foundation,
Yeah.
that solves, and then a new foundation is built inside
Okay.
in the lot
All
line.
right, I'll amend my position. I do think, though, we should, in deference to the neighborhood and ladies 12 inches there, put a condition in that no construction activity or any maintenance after construction go off of their property line without the neighbor's consent.
Sure, that's fine.
I think, so that way the neighbor doesn't have to just call the police department to report a trespass. We can make them remove the house, because it would be a condition to the grant of the special permit, which will get the owner's attention, whoever the current owner is then.
Given the neighbors' concerns, and they certainly are plenty, and the neighbors did not receive your information through your email, I'd like to see you reaffirm whatever it was you had thought you had sent to them. And maybe between the two families, the attorney and the family over here, can come to some sort of an agreement. I know it's going to be difficult, and it may not be possible, but I think you owe them that information that you thought you'd sent to them.
Yeah, if they didn't receive the email, I feel badly about that. I know my client, Mr. Barone, can tell you, he sent an email, very nice, saying we'd like to get together and chat about the project, and we never heard back. So that was the information. We never sent the protocol because we never heard back to the initial email, so we just assumed they weren't getting a response. But we're happy to discuss with them going forward in terms of, I can certainly, when I get back to my office tomorrow, send you a copy.
I would just, okay, it's always difficult, and we never, as a board, like to see the fact that we have a neighborhood, or two abutters, an applicant and a butter having difficulties such as this. And it's gonna be after this house is built, it's gonna be, you have a long-term relationship as abutters. And in the neighborhood, I just would highly recommend, if it's possible, that you, your client, and the Griffins would be able to come to some sort of agreement.
Yeah.
Particularly as it comes down to the long-term maintenance of the property.
Yeah.
Because I can see the fact that if it's not addressed now, and it's not taken care of now, you may have a long-term issue. But that's up between you folks.
Yep.
The board cannot
Sure.
dictate
No, it's
how people need to get along with each other.
it's very good advice, and I do appreciate your thoughts on that.
So, just so I get it down correctly, on an additional condition, David, you recommend that no construction and/or maintenance?
ongoing maintenance after construction extend onto any neighboring property. We make that a condition,
All right, no construction and ongoing maintenance
or and/or ongoing maintenance, yeah.
and/or,
Ongoing maintenance after construction shall extend onto any neighboring property. And we want the construction time restriction, of course, and our new general condition, that, you know, the two standard ones,
right.
and the foundation coming completely out of Atlantic. Existing foundation completely removed from Atlantic.
So we have three conditions.
Actually, well,
New ones plus the other, you know, the two
Yeah, that's
standard, the time and the
Just
new general.
Well, also,
one further point, just to reinforce, I think, why it's probably a good idea in the end to actually remove it, is eventually there's gonna be a sewer line down that street. And when that excavation happens, you don't want them telling you that
well, that's an excellent
it's
point.
concrete and
Yeah, that's a good point.
you're in the.
This is going to save you a lot of problems in the future.
I think with those changes, I do think the property meets the requirements of the bylaw, the proposed, meets the requirements of the bylaw, the Gale and the Deirdre cases, and will not be substantially more detrimental to the neighborhood than the existing structure is. Noting that some neighbors are upset, but the test is not just a few neighbors, the entire neighborhood. And if anything, I will think this would be an enhancement to the property values in the campgrounds. You know, just drive through, people are continually upgrading and improving the properties down there and improving the property values, so.
can I read from yours?
Um,
I got it down here. I got,
You're all set, okay. By the way, I apologize, I didn't write down who seconded the motion to close the public hearing.
me.
Okay. Okay, the chair will now entertain a motion on this case.
The motion is case number 2023-03. John D. Baroni and Karen D. Gagny, through their attorney, James Norcross, have been granted a special permit as owners of the property at 14 Atlantic Ave, assesses map 6B parcel L140 in the RH2 zoning district. Applicant seeks a special permit to raise, replace pre-existing non-conforming single-family dwelling pursuant to the Harwich zoning bylaws 32554 and MGL chapter 48, section 10.
If I might add to that, just, oh, you're going to? Oh, I'm sorry.
Okay, the board also grants the special permit based upon the Gale case. The proposed project will not intensify one or more existing nonconformities, will not create a new nonconformity, or will not be substantially more detrimental to the neighborhood than the existing structures. All work shall be performed in accordance with the plans submitted in this application. The following conditions. The property is located in a congested area. No demolition to the exterior construction to the new landscaping during the period of June 30 through Labor Day of any year. There is not possible way that any of the construction equipment is going to get on that property, so.
Not in July.
Not at any time. All right, the next condition is that, the conditions that a crane, should it be used, damages to town property will be protected and reimbursed. Secondly, the foundation shall be removed in the front.
Atlantic Street frontage.
Atlantic Street.
On Atlantic Street.
You completely removed, right.
Yeah. Completely removed from Atlantic Street.
Okay, all right, completely removed from Atlantic
Town
Street.
property, probably should say town property on
Yeah.
that.
Actually from town property on Atlantic Street.
Right. And number 3, no construction on ongoing maintenance exists onto neighboring property.
In the general one.
Yeah. And lastly, the conditions for this approval, that a violation of the terms and conditions of this special permit may be enforced as a violation of the Howard zoning bylaw pursuant to MGL Chapter 48, Section 7, the Howard zoning bylaw, as these may be amended from time to time.
I'll second that motion.
Any further discussion by the board members voting? Okay. All those in favor of on the motion?
Aye.
Aye.
Motion is approved.
Thank you very much.
Before the next case, we're just gonna take a quick 5-minute break.
Do you want the plans to stamp them, or do you have them?
I have them.
Okay.
I ended up with 2 copies. Is anyone missing one, or?
I got 2 copies as well. All right.
Is it hot in here, or is it me?
It's hot, yes it is, yeah. There's several reasons for that.
I don't know if they own it.
They opened that window. It was.
There's no alarms or anything on this, right?
You wanna just leave the doors open?
Yeah, I don't know.
Don't want people jumping out.
They open at the bottom.
You can open this one.
I got my-
Let the air in.
Welcome back, Chris.
Yeah, last week would have been a tough week for this meeting.
Yeah.
Coming up with jet lag.
Where'd you go?
New Zealand and Australia. But going there was easy because it was only a 6-hour difference.
Yeah.
But then I went to Australia, then daylight savings time. So coming back for 9.5 hours.
It's on the list.
So-
I missed the February meeting. We were in Hawaii. Quite a
See,
lot.
and that was, when I went to New Zealand, it wasn't bad. 6 hours is,
Yeah.
but when you start getting 9.5 and coming
Yeah.
this direction,
I used to,
Going west.
I quasi-commuted to London for about
Great
3.5
job, Dave.
years. Company apartment there, and I would go 10 days.
If I don't
or
lose my voice, I'm gonna be lucky.
5 days.
yeah.
And I would just, it was crazy.
So you never got out of jet lag.
Well, what I would do on 5-day trips is I would just stay on the East Coast.
Yeah.
I mean, I would just go to bed at 6 o'clock at night and wake up at,
Take your coat off.
it was just ridiculous, because otherwise you were screwed, just about the day you started being okay, you flew back again. And
Yeah.
That's why, after about the first 6 months, I started doing, my wife wasn't thrilled, but I was going every other week. I started going 2 weeks once a month,
Right.
because it just was crazy.
Who were you with then?
I was with a company called Empor. We were building the Jubilee Line extension,
Oh, okay.
subway.
Yeah.
You know, it was probably the most challenging construction project I was ever on in my life. It was,
All these unmarked things.
Yeah, digging underneath,
Kind of like the big
13th century London, but also they had a fire at King's Cross in like 1996, and they redesigned the project. But the whole purpose of the project was to be open for the millennium, so the Queen could go to Greenwich, or Greenwich Mean Time. The big station was at Greenwich, so the end date couldn't change.
And when did you do this?
So I was pretty much over there from 97 to the day it opened in 2000.
Really?
Back and forth, back and forth. I was finance guy, trying to make sure we didn't lose a shitload of money, but, down in the tunnels a lot.
Thank you for your
Of course,
patience.
that's when the
No problem.
bombings were happening. and,
Yes.
Oh, that's right, this is when, before the,
You know, it was just.
before they
delay
solved the
after
troubles.
delay. At one point, we were $60 million underwater on the project. Luckily, the British government did more. Okay, we didn't cause a fire at King's Cross, but the reason, they kept saying it opened
Well, that's a little better.
December 1999.
They do open.
They do. We were throwing people, it was so inefficient, just, 600 people working on a 28-foot line.
Yeah.
Before I forget,
Hi.
I'm gonna be gone next week,
Oh, sure. This is too much for you.
It was my trial by fire.
but
little
I'm
After
gonna
that,
have to have Lisa.
started running
make sure
part of the
we-
company, so.
The cases are all written,
And then they made my career, wow,
all the decisions done.
but I spent
You can go in and sign.
Yeah.
pretty much the last 20 years of my career, I was in the
Wait a second.
Yep.
What's our next case?
The next case is the 61 Joe Road.
couple of times a year in China. One time was, Europe, never, I didn't have to go, that was killer. There were guys that, I was in Singapore, and there were guys that I knew there, that every other week, they would go back to class, and it's 12 hours.
It was gonna kill me. It was gonna kill me. We couldn't hold this thing. It was a bankruptcy. There was no question, so it focused.
But you never had a jet lag.
Yeah, yeah.
You know, it's not good for your body.
You're like,
I did get into driving range.
I didn't.
We're back. I'd like to call the meeting back to order, and if our clerk could read the next case.
Case number 2023-04, James C. and Tracy M. Fish, through their attorney Miriam Rose. They're the owners of the property located at 61 Shore Road, Assessors Map M2, parcel B1-1 in the RL zoning district. The applicant seeks a special permit to raise and replace pre-existing non-conforming single-family dwelling pursuant to the Harwich zoning bylaw, Chapter 325-54, and MGL Chapters 40A, Section 6. I have in my possession here a letter from a property owner at number 58 Shore Road. Did you receive that, attorney?
No, I did not receive that. I asked
Okay.
whether there were any other letters
Say,
today.
The person's name is Elizabeth Naughton.
I'm gonna share my copy.
Okay,
All right.
sure.
2 o'clock today.
2 o'clock today.
I sent an email over to town a little earlier.
Well, we're carrying on to indicate who's gonna be voting tonight and so forth. Why don't you take a moment to read that?
Thank
Okay.
you.
All right. Should we get started? Now, while Attorney Rose is reading that documentation, voting on tonight's meeting will be, on this meeting, in this case here, will be Al Donahue, myself, David Nunnally, Chris Murphy, and Dave Ryer. Okay. John, just so you know, even though you're not voting, you can participate in the meeting, ask questions and so forth. All right, this letter I just gave you, so what? We're gonna discuss first or something. You know, this particular letter. That was great. Was the presentation?
Okay, sure.
Okay.
No, I had it.
We could share some. No, I'm all set.
Yeah, that's the one we don't.
If you, about the comment that it seems to be incomplete, I agree with
Yes.
you, okay?
Yes.
And we'll get into that a little bit later, but
Correct.
are you familiar at all, based upon title search and so forth, with the issues that have been?
No, I'm not familiar with this
Okay,
at all.
all right.
Um,
We will address it, but I just wanted to get
course.
things started.
Right.
Okay, so, I'd like to ask the applicant to introduce themselves and who you're
Certainly.
with and so forth.
Certainly. My name is Marion Rose. I'm from Singer and Singer in
Excuse me,
Dennisport.
just a little more volume.
Absolutely.
For those of us that are hearing
Can-
challenged.
Certainly.
Thanks.
There's an art to this. Can you hear me now?
Yes.
Great. My name is Marion Rose. I'm from Singer and Singer in Dennisport. I'm here on behalf of the Fishes. To my right is Tim Loft. He's the architect on the project. And Dan Croto is here as well, in case there are any questions of a surveying or engineering type. The Fishes aren't here. They're from Texas, and they'd hoped to be here through Zoom tonight, but could not. The Fishes own the waterfront property at 61 Shore Road in West Harwich. It's located in the RL zoning district, and it's improved with a 2-story single-family dwelling, a rear-facing deck, and a walkway to the water. The existing structure is pre-existing, non-conforming as to both east and west side setbacks, and marginally as to height. The lot is non-conforming as to lot size. It's roughly 28,000 square feet, where 40,000 square feet is required currently. And lot frontage, 75 feet or plus or minus existing, where 150 square feet is required. The front and rear yard setbacks, building coverage, and site coverage are each conforming. The applicants propose to raise and replace the existing structure and construct a 2-story, single-family home with a patio and pool, which will be less non-conforming as to both east and west side setbacks and conforming as to height. The proposed structure will be actually, I've just said that. The proposed structure will be non-conforming as to side setbacks on both the east and west sides by roughly 2 feet on either side. The proposed dwelling will be shifted further away from the 50-foot resource area, and a significant portion of the structure will be located outside the 100-foot resource area, buffer area. Site coverage and building coverage will remain conforming with the proposed structure. The reliefs required because portions of the existing dwelling are located within setbacks and because the proposed new construction does not meet the current setback requirements. The project has undergone review from various town departments. The Conservation Commission has reviewed the proposed project and approved the plan as submitted to this board. The number of bedrooms for the existing and proposed dwelling is 5, will remain the same. The Board of Health review is not anticipated as the site is Title V compliant and no variances are required or sought. I'm learning now tonight of the new opposition of the neighbor across the street, but I would like to emphasize that the direct abutters on either side of this property have sent letters in support of this project.
Correct.
I hope those are already in the record, but I have them here if I need to read those into the record.
I believe I saw one of the, I only saw one. Paul,
Number 50,
It's both the Nolans of 55 Shore Road and the Cormiers of 65 Shore Road. I have copies of both of those emails to Leisha in my possession.
But
and I
both,
could-
both the abutters on your side have approved
Correct,
going forward.
correct. The only
Are in
wish they
favor.
had was that, construction not be done in the summertime, so.
Sure.
The applicant is seeking a special permit under section 325-54, section A, section 5 of the Harwich zoning bylaw in order to complete the work as shown on the plans. Under the Harwich zoning bylaw, pre-existing non-conforming single-family residential structures may be demolished and replaced by special permit upon a showing that the proposal will not be substantially more detrimental to the neighborhood than the existing existing structures, and that at least one of the dimensional nonconformities of the structure will be improved. The applicants respectfully submit that the proposal will not be substantially more detrimental to the neighborhood than the existing structure because of the following. There'll be no change in the use of the structure. It will continue to be used as a single-family dwelling for residential use. There'll be no new nonconformities. Building coverage will be, which is now 13.4%, which is now 10.7%, will increase to 13.4%, where 15% is conforming. Site coverage will also remain conforming. 26.6% existing, 27.3% proposed, where 30% is conforming or allowed. The project as proposed will decrease, as I've mentioned, both the east and west side setbacks by roughly 2 feet on each side. And the height of the building will decrease to 29 feet, 11 inches. The proposed plan shows clear environmental benefits by pulling the dwelling and a significant portion of the patio outside the 50-foot wetland resource area. And the property, as I've mentioned, is compliant under Title V. We believe that the structure to replace the current structure is appropriately sized for the lot and the surrounding renovated structures, and is compatible in terms of size and scope with the character of the neighborhood, and is supported by the applicant's immediate abutters. There's adequate off-street parking for the continued residential use of the property. There's no change anticipated in traffic flow. The proposal, we believe, will not create any nuisance, hazard, or congestion, or any harm to the neighborhood, nor adversely affect the public health, safety, convenience, or general welfare of the town. For all of these reasons, the applicants respectfully request that a special permit be granted to allow the project to be constructed as shown in the submitted plans. I guess I'd also, before any questions that you might have, I'd like to mention, I'd like to circle back to this letter. I believe the letter, although it's incomplete, is an agreement between the prior parties as to landscape plans and not necessarily the placement of the house, but I don't have a second page, so I'm not certain. And I don't know if this is something that continues with the land after the property is sold, or if it was just an individual agreement between the two parties. I have no idea.
Yeah, I'm not, we're gonna kind of work through that in discussion, but it is incomplete. We don't know the background of it. We'll address that in a moment. As the chairman asks for any comments or questions from the board? John?
Just one or two. So you're increasing the building coverage, but reducing this, increasing the site coverage, but by about 250 feet less, square feet less. Is that removing hardscaping somewhere? Is the driveway going to change to some less permeable surface, or how are you achieving that difference?
I think I've got somebody that can answer that for you.
Good evening, Dan Croto from Moran Engineering. So the proposal, the site coverage increases with the proposal from 25.6 to 27.3. And the building coverage increases.
Yeah, but the site coverage increases by about 250 square feet less than the building increases, so somewhere, something's disappearing.
Oh, let's see, so the site coverage increase,
Either the deck or the permeable driveway. It's a paved
It's-
driveway now, I'm kind of,
the driveway size, I guess probably be decreasing. I'd have to look at the numbers close, the full numbers, but I had heavily gone through this for the conservation.
it's somewhat of a curiosity
Square foot
question,
meter.
just more.
Right, I'm sorry, I don't
Sure
know
it's gonna
that.
affect the outcome, but also, I'm relatively new to the board, so I'm trying to
You're doing well, John.
keep it up. The other question, and sorry to move on from that, you guys, I guess, can come back with that. The 100-foot setback from the dune, it says a significant portion of the structure will be located, but it looks to me like it's then only the garage section. Is that significant?
I feel like it's significant.
Right.
I'm not saying it's most,
So it's really only about 20%
right,
of the square footage? Just wanted to make sure I wasn't
no,
reading something properly.
no. I mean, generally, the proposed structure is slightly less wide
Right.
than the existing structure, and it is being moved back away from the Nantucket Sound, mainly because of Conservation Commission concerns. And it's a narrow lot, and there's only one place to move it.
But is which I think is the answer, maybe not to put words in your mouth, is the parking area going to be permeable, or is it going to be paved?
Parking area, whether it's permeable or
Doesn't matter.
permeable
Does
or
not matter
paved,
for
is
the
site.
square
Doesn't matter,
Okay.
right,
So I think it is gonna be paved.
So it has to be somewhere in the patio size or
Right.
something. Chris?
Yeah, coming in here, this seemed rather straightforward, I guess.
I thought so too.
And the letter, obviously, which is incomplete, raises some issues. But actually, from the pictures, I believe it's the right side, you're taking 2 feet away from that obstruction. You're actually increasing, you're decreasing the non-conformance by 2 feet, is that right?
Correct,
So you're going from 12 to 14, which will increase the view of Nantucket Sound from across the street.
that's true.
That's
There'll be a wider view
It'll
corridor.
be a better view.
Yes.
True,
You are going up, but
Yes,
that's gonna
but
block,
it's
that's
a
gonna block the
two-story-
airflow probably, which I'm not sure that is something
it's a
that matters.
two-story house now, and so
Yeah, not
it's
in that right side, it's, looks like it's a one-story piece.
over the garages.
But it looks like you're going to improve the situation for this.
Correct.
But without the full letter, it's difficult to know where it all fits in.
Right.
But again, it was rather straightforward until this letter was put in place.
I think in general, the design challenge here was to try to recreate a new house meeting their program, but be considerate of increasing the conformity or decreasing the nonconformity on the two sides. So the design premise when we went into the design studio was to take a minimum of 2 feet off of each side. Then as we worked through conservation, we then had to push the house towards Shore Street. And if you look at this, it's not a complete rectangle, right? It's a parallelogram. So as you push the house farther, it creates a more of a pinch point at the garage. So trying to work all of those things in to satisfy the different boards, that was the design objective, and then having to possibly decrease and go back to the drawing board. But that was the design premise. And the two neighbors were understood, and I've had multiple conversations with what's 55 Shore Drive in terms of trying to satisfy some of his concerns and needs. And he had conversations with the other abutters. So we were really trying to work this as a team from the get-go. And we produced the height to what I would call a gambrel, more of a story and a half structure as opposed to a full 2-story. That was the design objective.
I have no questions.
I only had a, thank you. Just out of curiosity, the back of the house is a 2.5 square by 2.5 height brick platform sitting in the middle of the lot in the rear. Just a, I'm assuming that that's something that, it's not shown on the plan.
Okay.
There's a block grill, like a,
Yeah, it's 2.5,
Red brick.
2.5 feet wide, square, height.
that was, that's being removed on the proposed.
Okay, I didn't
For
see it on there.
conservation.
Yeah, no,
There's
Yeah,
a
it
note,
is
remove
there.
block
yeah,
grille.
in, just above, just below where it says remove existing deck, it says remove block grill.
Okay, I missed, okay, that's the block rule being referred to, okay.
Yeah.
All right, thank you, I just, all right. And the Board of Health, just to, were there any plans to expand the family suite from a kitchenette to a full kitchen?
No,
Okay. All right, because that was one concern of the health department.
absolutely, understood, no.
And what is your time frame on the project?
I believe that the construction would start in the fall.
I think that they want to try to,
They
they want to try to get started if
That's
we
true.
can, get started and get to a point and then,
And stop.
and stop. And if we can get the foundation and the deck on, get a security fence around the structure, get it graded, get the machines out of there, and let the neighbors enjoy the summer, then we come back and start framing in the fall. That's what we hope to do.
Okay, so you're gonna be taking it down.
Take it down, excavate, pour foundation, put the deck on, and then put a security fence around the perimeter of the foundation,
You're looking to do that, accomplish that by June?
if we
Correct.
can.
Yeah.
Yeah, if we can. Just because construction, getting the framing going in September, depending on what winter throws at us, and getting this all tight to weather is not always the easiest thing. So we're hoping if we could get that part done,
Sure.
we would be good. And then, would certainly open up views, at least for the butter across the street for the summer anyway.
Okay.
I have no questions. I think it meets the requirements of the bylaw, the Gale and Deirdre cases, and I do think we'll want our construction time condition and then the general condition, the new one.
No questions?
David?
Okay. Just a thought regarding the letter that, from Elizabeth Norton, your 58 Shore Road. Obviously, one of the concerns was the house being moved forward, but if the other boards, the Conservation Commission and so forth, and, has requested that change, it was one that's being done to meet requirements of the town.
Right.
Betters, much, betters the situation. Dan can
Right.
speak to
So
that.
I think it's, in my impression, that the town has required this to be done to, do this project.
Exactly, and the abutter would have had notice of the conservation meetings, which,
Right, so there was an opportunity.
Right.
Now, obviously, we don't have the second page or the third or fourth page on this. That could have been an error from our own department as far as making the
Understood.
copies. I don't know. But I just wanted to understood the fact that going forward, should the board vote the special permit, that you still would find yourselves, whatever requirements are in here, to make sure it's researched,
yes,
because there may be a legal precedent here that you need to be aware of prior to going forward with your project.
understood.
But-
Just out of curiosity, you said this talked to the two abutters on the left and right. Did they reach out to you?
Correct.
And so that's why-
Exactly. Very quickly. Very quickly.
So I just want to make that point,
Certainly,
all right, that it's, beware.
Right.
Because and check things out prior to going.
Right.
Okay. I'd like to,
I'm actually curious, when this was purchased, it seems like this would have been something that
up, I think.
would have been picked up at the time of purchase, so, but I'm
That's
going
why
to
we
go
all
through
pay
it.
Tyler Court
Exactly.
insurance,
But I
correct?
will be going through it
Okay.
tomorrow, no doubt.
Now, are there any members, any in the public that would like to speak regarding this case? Okay.
I'll move to close the public hearing, seeing no one come forward. Dave?
Okay, any further discussion by the board?
Just one question I have regarding when the tear down is done and the security fence is put in, it'll be in the summertime, it'll be a whole bunch of little nippers running all around the beach area. Is that gonna be encircle the entire piece of property to prevent anybody coming in from the
Correct.
beach side and everything else?
Correct, and I can verify from the general contractor, it may be that as an insurance issue, depending on what insurance agent the homeowners choose. If it's Chubb, we're gonna have to have a perimeter 8-foot tall fence all the way around with a lock on it. It just ensures the entire construction. But I don't know what they have, but at the very minimum, we would have a fence around the entire foundation that nobody would, 4 feet tall, that nobody would be able to get over the top of. But I think we could end up having a fence on the perimeter of the property lines with a gate and a lock.
Will the pool go in after the house is all up? You're not gonna dig it and put it in and leave it just an empty pool there?
Correct. I don't think we have time to put the pool in, but I think we have ample room on the sides, and I think the neighbors being cognizant of what we're trying to do here, that would allow us to get a machine back there to
Right.
dig that up in the
Because that would
fall.
go to Al's point about.
I just think logistically, there's not enough time to get that done
Yeah.
before the fall.
I would just bring your attention to the property owner and yourselves. There's been a few problems regarding drinking on the beaches. I don't know if you're aware of it. And during the summer months, my concern is that this property, if it's not really secured well, that may be a real headache
Right.
for the property owner. So you may want to really consider how to make sure you secure that so you don't have any headaches.
If the board wants to make that we have a full gate around the perimeter with a lock, I mean, a proper gate as opposed to just around the perimeter of the foundation, I would say that I'm sure that the contractor and the homeowner, knowing who they are, would want to have that in place. So we could just go ahead and make that part of the
That's fine.
conditions.
All right.
That's an insurance company's.
Yeah, whatever you've, do we,
No.
I'll now entertain a motion by the clerk.
All right, case number 2023-04, James C. and Tracy M. Fish, through their attorney, Mary Rose Esquire. They are the property owners of 61 Shore Road, have been granted a special permit. This is Assessors Map 2, parcel B1-1 in the RL zoning district, pursuant to the Howard zoning bylaws 325-54 and MGL Chapter 48, Section 6. The property is going to, property meets the Gale case, and the proposed project will intensify one or more existing nonconformities, will not create a new nonconformity, and will not be substantially more detrimental to the neighborhood than the existing structures. All work should be performed in accordance with the plans submitted with the application. The special permit is granted on the subject to the following conditions. There shall be no demolition, exterior construction, or new landscaping during the period of June 30 through Labor Day of any year. During the life of the project, are you going to be able to get equipment on that property even in the fall?
Okay.
All right. During the life of the project, all construction vehicles shall be parked on the property and not in any public street or road. The next condition, which is probably beyond my scope of actually requesting it, but I'm gonna put it down anyways, is there be a full security fence placed around that property during the time,
Around the construction,
during the construction,
around the,
right,
around the foundation.
foundation construction, but also to include the back area. All right. It is a condition of this approval that the violation of terms and conditions of this special permit may be enforced as violations of the Howard zoning bylaw pursuant to MGL Chapter 48, Section 7, and the Howard zoning bylaws as these may be amended from time to time.
I'll second that motion.
Can I just, before, we, on the full security fence around any excavated land?
Yeah.
Would that cover it better that way? That way, anything that's excavated, you need to have a security fence.
Certainly.
Yeah,
And if-
makes sense.
That, I mean, if we word it that way.
Sure.
We may do more.
Right.
But,
Whatever, so
yes,
full security fence, that is, that is lockable, that is locked, around any excavated land,
perfect.
okay? All right,
You amend your motion,
I amend my motion.
and I'll second the amended motion.
okay. All right. Second by Dave Ryan. Okay. All those in favor?
Aye.
Aye.
Thank you.
Motion
all.
approved.
Thank you.
May I take this?
Yes.
Thank you. Okay.
You want to hang on to this, Brian?
Yeah, that'd be great, thank you.
You're welcome.
I don't remember that one. Oh, no, you're absolutely right.
Is the next one continued?
Yeah, let's see.
Is there anyone here, I don't believe, is there anybody here from Fort Cove Landing? Okay, all right, so why don't you read the case and then we'll do the continuance.
All right, case number 2023-05, Road Cover Resort Owner LLC, and Four Cove Landing Road LLC, through their attorney Miriam Rose Esquire. The property is located at 2173 Route 28, Four Cove Landing Road and 2 Swan Drive, Assessors Map 115, parcel S1, 3R2 and H52.
Did Mary just say this?
Yeah, she did. In the CH2 zoning district, the applicants seek a special permit or any alternative existing non-conforming amenities coverage and to increase an allowed use of more than 7,500 square feet in gross floor area pursuant to the Howard zoning bylaw 32554 and MGL 40A. There's been a request that this case be continued to our April meeting.
I'd like to make a motion that we continue the meeting,
Continue to,
April meeting,
okay,
okay? Otherwise, I'd have to do the,
right.
right. Okay, and David, you second it. All those in favor of continuing the meeting?
Aye.
Motion approved. Yeah.
Case number 2023-06, Richard S. Tupper, through his attorney, William D. Kroll. The owner of the property is Warren Shore Drive, Assessors Map 78, parcel B10 in the RR zoning district. The applicant seeks a special permit or any alternative, a variance to add a porch on the rear deck to the pre-existing non-conforming single-family dwelling pursuant to the Harwich zoning bylaw 325-52 and 54, and MGL Chapter 48, Section 6 and 10.
Okay, voting on the meeting, this,
Just gonna put this on.
voting this case tonight will be Al Donahue, Dave Nunnally, Chris Murphy, David Ryer, and John August. And ask the applicant, Attorney Crowell, to identify yourselves and who's with you.
Thank you, Mr. Chairman. Good to see everybody. Thank you for continuing the previous case. That would have been another hour, hour and a half, I'm sure. So here we are. And Mr. Donahue, just so you know, in the first case, you're concerned about a crane. My father was a crane operator, and my brother and my uncle were all crane operators, and I was the peon for the outriggers that go out and make sure you don't damage the street and the yard and so forth. So if you need any consulting work from me on, when that comes up,
I certainly will refer your name to the...
happy to monitor it for you.
Thank you.
He might have already given him a bid.
So,
Everybody's got to have a side gig on
that's it. Right.
I thought I saw his business guy being passed out. I wasn't quite sure.
Those were the good old days. All right, so this, I'm Attorney William Crowell from Harwich Port, and I'm representing Richard Tupper, who is seated beside me, the homeowner, this evening. And this property is up by Robbins Pond in North Harwich. It's not the same shore road that you were just addressing. This is Shore Drive. And it's a much more, shall we say, laid-back, cottagey type environment and neighborhood. So I submitted a copy of the assessor's map just to orient you with the location of the property. And it's on the corner of Shore Drive and Cahoon Road there. It's an L-shaped, basically an L-shaped lot. Mr. Tupper has already been approved by the Conservation Commission for this project and has the approval of the endorsement of the Board of Health. That they submitted a comment to you saying they had no problem with this. So there's an existing covered porch, and when you look at the plot plan, make sure you look at the detail on the left, because you can read that a lot easier than you can the smaller detail of the lot itself in the middle. So on that detail, on the existing dwelling, which is the top picture, it has a covered porch, and that porch is in two points. It's 19.3 feet from Cahoon Road on the north and 20.2 feet from Shore Drive on the east. So it's less than the 25 feet setback that's required in that zone, so it's a pre-existing non-conforming setback. More on the Gale case in a minute. The southwest corner of the existing dwelling is 16.7 feet, as shown in that picture, in the area where we want to put a deck. So that's non-conforming because the requirement is 20 feet. So our argument is going to be that to construct the wraparound porch that is shown on the proposed addition and proposed deck, for both the wraparound porch and the deck, in accordance with the Gale case, that this board, we're going to ask this board to grant a special permit on the grounds that it would not, these improvements would not constitute a substantial detriment to the entire neighborhood. And as I said in my narrative, I point out that the deck actually would be 10 feet from the lot line, and there's a provision in the bylaw that even though that's non-conforming, it's allowed if the deck is under 4 feet in height. It's gonna be 2 to 4 feet in height. So it would comply with that section of the bylaw. And as far as this being a corner lot, if there's any concern about the site on the corner, these are both private roads. This is not a busy neighborhood. There's a large amount of vegetation in front of the existing covered porch that Mr. Tupper is going to take out entirely, so that the sight line would improve significantly, and the new porch will have no screens or walls. You'd be able to look through it. It's just the upright and the railings that are required by the code, and the balusters for the steps. So the sight line would be improved. The existing building coverage would stay under the 15% maximum. It's currently 10.3, and it will actually decrease to 9.9. And similarly, the site coverage will decrease from 31% to 29.2%. It's already over the 25% maximum, but we're making it more conforming by reducing it a little bit. So we have obtained the so-called denial letter from the building commissioner, and would argue that the additions will not result in any substantial increase in noise, odors, fumes, congestion, traffic, or the like would not constitute a nuisance and would not be a substantial detriment to the entire neighborhood. We ask that you grant the special permit this evening. Thank you.
Okay, thank you. David, any questions?
No questions.
No questions.
What is your time frame?
Go ahead. Go ahead.
We've been working on the permit for over a year now, so, we'd like to get going as soon as possible. It is a quiet neighborhood. I've been there in the summer and, other than year-round residents, the people across the street come down maybe 1 or 2 weekends a month, so I don't think, and we're not raising and replacing, we're basically just rebuilding what's there.
Yeah, I'm not familiar with that area, but it appears to me there's not a lot of I don't think there's an increase of summer activity or traffic that's going on that street that's.
It's not Harwich Port, and it's not Lower County.
No.
Yeah.
It's not that type of neighborhood.
One of the reasons I picked it. It's quiet.
Will you be able to maintain, most of the construction vehicles on your property?
Yes. There's plenty of parking down below and up above.
Okay. I bring that up because I don't know whether or not we need any restrictions on time frame or whatever on this project.
I think we still have to make the restriction regardless.
It is a private road.
The restriction that we park on the site, but we just as soon not have a time restriction
No,
about.
we won't do a time restriction on the site.
All right, but we can get all the vehicles on the site, yes.
Right, but time-wise, we're not going to restrict the June 30th to.
No.
Thank you.
Okay, all right. Okay.
I'm just curious, you're still gonna maintain the wood stove?
No. I had a problem with the wood stove years ago, and I'll never do that again.
I noticed you have a nice stack of wood back there.
Oh, yeah, you're welcome to
Do
it.
you want some of it, Al, or is this way trying to drive by
It's
your
the time
truck?
to get it.
That's
So you
okay.
saw the house.
I did, yes, I did.
Nothing escapes Mr. Dunn. He's got that, I know his background, he's got that eagle eye.
Chris?
On this plan, it looks like a house plan. Are you just putting a deck on, or you?
Yeah,
What do
the
you got? Are
existing house, we're switching the dormers around so that we have 2 doghouse dormers out the front and putting a full dormer on the back. The first floor is, we're maintaining the first floor walls and building up from there. And the decks are added, the rear deck is needed for rear egress anyways, because we're adding a rear door. The side door, if you've been over to the property, it's like there's a steel fire escape on the side, and we're getting rid of all of that and putting the farmer's porch on the front.
So besides the deck, you're here front for us here, you're doing a lot of construction inside the house.
Inside the house, yeah.
You
And
basically,
that doesn't require, what you're doing won't require any zoning issues. It's not, you don't need to come before the board for anything else other than the deck?
No, other than the deck, no, because, again, originally, we planned on, raising the foundation, starting over, but with all the wetlands issues and everything, we decided we're just gonna keep the footprint and, improve it from there. Yeah, I mean, there's an existing door, but we're rearranging it, so we have the dog houses in the front.
You're not widening it.
No, it's all the same.
No other questions?
So you're achieving the reduction in the lot coverage by removing the shed that's there right now?
The shed and the front porch was an enclosed porch, and now it's gonna be an open porch.
Any other questions?
okay. I just had one other. Okay, all righty. Are there any comments or questions, anyone from the public tonight want to speak to this case? Okay, hearing none, I move that we adjourn the public meeting. Close the public meeting. We just got you, okay, Chris?
Yeah.
Any additional discussion by the board?
I just wanted to check with him, make sure you're gonna support that metal Vestas pipe off the back. You're gonna support that
Yeah, that's
metal
true, yeah.
Vestas pipe for the stove? You're gonna move those concrete blocks that are holding it up?
Yeah, that whole thing's going. I mean, the pipe's going, the fireplace,
No,
that's
I'm
all gone.
pulling
Yeah, I
my
know.
leg.
Well, let there not be any doubt that we actually go to these properties, look them over.
So you know what's there.
Well, I did notice a couple of bushes growing in the gutter.
Yeah, we have Fred in the attic too. It's a raccoon.
I bet you do. There's a lot of means of egress for that raccoon.
Yes, there is.
Gentlemen, I failed to ask for a vote on the motion to close public meeting. All those in favor?
Aye.
Okay, I'd like to ask the clerk to make a motion.
Okay. Case number 2023 dash 06, Richard S. Tubrick, through his attorney, William Kroll, have been granted a special permit for One Shore One Shore Drive.
Can't make that
Myself.
mistake. My taxes will go up.
You will go up too.
Assessors map parcel B10 in the RR zoning district. The applicant seeks a special permit, has been granted a special permit to add a porch in the rear deck in the pre-existing non-conforming single-family home pursuant to the zoning bylaws 325, 52, and 54, and MGL Chapter 48, Section 6s and 10. The proposed project will intensify one or more existing nonconformities, will not create any new nonconformities, and will not be substantially more detrimental to the neighborhood than the existing structures. All work shall be performed in accordance with the plans submitted with this application. The property is not a congested area. During the life of the project, all construction vehicles shall be parked on the property and not on a public or private road. Let's see, it is a condition of this approval that a violation of the terms and conditions of this special permit may be enforced as a violation of the Harwich zoning bylaw pursuant to MGL Chapter 40A, Section 7, and the Harwich zoning bylaw, as these may be amended from time to time.
Second the motion.
Any further discussion by the board? Okay. All those in favor of the motion?
Aye.
Approved.
Thank you very much.
Thanks, gentlemen.
Mr. Kroll.
Thank you, sir.
Okay, you're welcome.
Have a good night.
Mr. Kroll.
Yes.
How was your knee?
He's doing fine. I've been playing volleyball for the last 6 weeks now.
All right,
So,
alrighty.
he's doing great.
He's my
Thank you
hero.
for asking.
Having gone through the same surgery, I didn't fare as well as you did as far as up and at 'em so quickly.
Too busy with this stuff. I couldn't afford to take much time off.
Oh, get me a violin. Okay, this one is done.
I'd ask the clerk to call the next case.
All right, case number 2023-07, Paula M. Delroy, and through the trustee of Padwatch Trust, care of, through their attorney, William Kroll. The owner of the property is located at 2 Andrews River Road, assessors map 16, parcel A1-B in the RL zoning district. The applicant seeks a special permit or, in the alternative, a variance to convert a garage to a habitable space on the pre-existing non-conforming single-family dwelling pursuant to the Harwich zoning bylaws 325-52 and 54 and Mass General Law, Chapter 40A and Section 6 and 10.
All the notices from all the town boards or departments came back positive, but the Board of Health was to meet on 3/21. Was that?
They
done?
did, and they approved.
Okay. All righty, on this case, assigned for voting will be Al Donahue, Dave Nunnally, Chris Murphy, David Ryer, and John August. I'd like to ask the applicant and his representative to introduce themselves and
Thank you, Mr. Chairperson. Attorney Bill Kroll, William Kroll from Harwich Port, and I'm representing Paula Delorey, who is seated behind me in the blue, and this is her husband, Paul Delorey, who she's designated as her agent to be her spokesperson this evening. And they are the owners. Paula is a trustee of the trust, Pataroo Trust, is the owner at the property at 2 Andrews River Road. The assessors map that I submitted shows you the location of this property, which is off of Neal Road. You go past Saquatucket Harbor, and your first right is Neal Road, and then you go down a bit, and then there's this Andrews River Road. The plot plan shows you the outline of the existing dwelling, and we're not asking to change the footprint of that existing dwelling at all. I will say that this house was quite neglected before the Deloreys bought it, and then a raccoon had his way with it, and really caused a lot of damage to the interior of that house. So that they had to, the builder had to go in and strip the interior of the house down to the studs because of all the damage from the raccoon. So in any event, what the Deloreys is seeking to do, because they're not changing the footprint, is that you see the part of the structure that is closest to Andrews River Road, and even though on the plans for the existing dwelling, it says that that's a garage, it has not been used as a garage for a very long time, at least the last 11 years, if not more. The previous owner prior to the Delories owning it, said that he never used it as a garage. It was always used as a storage space and for mechanicals, and when the Downey family owned it, they lifted weights in that room. So it was basically quasi-habitable space to begin with. I have a photograph, if you'd like to see it, to show you that it's certainly doesn't look like a garage. It looks like it's part of the dwelling already, and has been that way for a long time.
Thank you.
When was this picture taken?
2011. In 2011. You want to share that?
Good.
And that's what it looks today.
Well, no longer, we've changed that, but when we bought it, that's the way it looked. That's what it's been.
2 years ago.
2 years ago.
2 years ago, when the Delories bought it, it still looked like this, in this picture. But regardless, I don't think that's really that relevant an issue. What they're seeking to do, which this board has done many times, is to have that, even if it was a garage, to have that now converted to habitable space. And you can see from the plans for the proposed renovation that that garage goes away, and that's now living space, and it's wide open, which is why the Board of Health had no issue with it. They're not changing the number of bedrooms, anything like that. It doesn't affect the septic system. And renovating the interior of the property. So the existing structure closest to Andrews River Road is 9.3 feet from the road, so it's a pre-existing non-conforming situation, and in accordance with the Gale case, they're seeking to intensify the non-conformity by converting that to habitable space, the interior of the structure to habitable space, which is, as I said, the board has done that numerous times in the past. So that's what we're asking for, and our argument is that, again, there would be no substantial increase in noise, odors, fumes, traffic congestion, or the like. It would not constitute a nuisance. It would not be a substantial detriment to the entire neighborhood. I know that there is a comment on file by the Conservation Commission, but I don't think that's within the purview or jurisdiction of this board as to whether it has to be, the property or the renovation has to be FEMA compliant or anything of that nature. That's between the owners and the Conservation Commission and the Building Commissioner. I don't think it's, with all due respect, I don't think it's within your jurisdiction. So I don't really think that that's relevant to the conversation or the presentation tonight. Thank you.
Okay, thank you. Your timeframe? I've obviously seen the house, it's been gutted, and it's ready to start construction, I believe. But what is your timeframe?
I guess it
Go
will-
ahead, Nancy. Go ahead.
It will, I guess it will depend on whether or not we're gonna be required to come to FEMA compliance.
Okay.
The first phase of the construction was done essentially to secure the house. You can see the pictures, it was just a mess. The roof was leaking, several of the windows were inoperable, some were broken. And our original plan was just to hire a commercial cleaning company to clean up, hopefully, the mess that the raccoon made, strip the floors, resand them, and paint. And we get in there, just couldn't do it. It was a mess. It had to be gutted. So at this point in time, we're stopped. And, the second phase began and the building inspector came down. There was a permit pulled for it, but the building inspector hadn't issued it yet. They applied for it. So we'd like to go right back and continue if we could, but again, that will depend on our conversation with him.
Attorney Crowell knows I always like to be educated What would, and I don't believe, as a member here, and you're a member, I don't believe the FEMA requirement is on the purview of this board, but I would like to know how that would impact the project.
Since we're not changing the footprint, I'll make a comment, and I'm going to defer to Mr. Croto. But there is a provision in our bylaw that says that if they had to raise the structure, lift it up, okay, to be FEMA compliant, that Section 325-108 of our bylaw says they can do so without the need for Board of Appeals relief, so that you don't have to come running back to the Board of Appeals every time that FEMA comes into play.
So FEMA could possibly require you to lift the building up?
The building commissioner could.
I see.
Now,
You would have to come back if you have to change the floor plan and the site plan, right?
no, not if we're not changing the footprint.
But if you have to change the footprint, is what I'm saying,
Right.
then you'd have to come back.
Correct.
Okay, that's all.
That's all. So any foundation changes of the footprint that may be required to meet FEMA's requirements, then you have to come back.
Right.
Now, Mr. Croto wants to make a comment, I believe, if that's all right.
And I appreciate the education.
Well, now that you're chairperson, I thought that you had already been educated and elevated to the alpha dog
Dave's doing his
position.
best, he's still trying to, bring me along here. He's hoping he could totally pass the gavel, as soon as possible.
Dan Croto from Moran Engineering. It's not a site coverage question, so I should be more clear. With if the FEMA requirements are needed, which means if the building inspector sees it as a substantial improvement, meaning more than 50% of the foundation has to be rebuilt, or the value is over a certain level, then he would deem it that the whole structure would need to meet FEMA, which means the structure in place could be lifted about 4 feet or so. The town, because of Sandy and FEMA, Hurricane Sandy pushing things, this town, along with most of the towns in the Cape, has made it a lot easier to take an existing structure and just lift it straight up to meet FEMA requirements. And I don't believe it would have to come back to Board of Appeals, because the idea was to get people on a fast track to just make their houses, an existing house, FEMA compliant. So I believe if it's approved today, it would still cover the owners if they just took that same exact structure and went up 4 feet.
So the non-compliance is the elevation of the basement? Is that?
Non-compliance would be the first floor of the house needs to be above elevation 11, whereas right now it's at elevation 8. Generally, you go on another foot above that, because anything below elevation 11, or the building, FEMA, the state building code is 1 foot more stringent than FEMA. So you take the elevation 11, you add a foot. Anything below elevation 12 needs to be flood compliant construction. So, did that answer your question?
Well, if I may, we're not asking for any relief with regard to FEMA tonight,
realize that.
because our position is that we don't need to do it.
Right, I recognize that.
And that to lift it up to this height makes it a castle.
That was for education purposes only.
See, I was
Yeah.
trying to improve my education here, so I just,
It's a small structure to begin with, so even lifted up, you're not even looking at a 2-story structure.
Thank you.
okay, thank you very much. I appreciate that. Okay,
Anytime.
all right. John, any questions for the?
No questions. The only question I had, the Andrews River Road, that includes the parking area that has adjacent to the property. There's kind of a semicircle of asphalt down there with no parking signs all over it.
Yes, that's
Part of your property.
It's part of the property. It's a different address. That's 9 Meadowmere, but yes, that's all part of the property.
Okay.
Okay. David?
Yeah, I just want to make a comment to the board. Very often I raise an objection on garages that under 354, what is it, 325-54A7, alteration or extension of other structures, a garage, requires a variance. Okay? The special permit provisions really only apply to single-family or two-family residential structures. However, this board has always historically taken the position that where the garage is attached, as opposed to detached, it is part and parcel of the single-family structure, which you think about, I mean, it's very logical. So we've always proceeded under special permits with attached garages when they're being altered or expanded or whatever. So I just want to make that, because most of these guys haven't been here, we haven't had a case like this in a long time. And it might have been Attorney Crowell who brought it up down in the Neal Road area. But maybe not, but that's when, I mean, we had a huge discussion.
It wasn't me.
Okay.
But I've had several of these approved by this board.
Yeah, right, and I just want to make the comment for the newer board members.
Very good.
Okay, that's, I don't have any questions.
That's 325-54-7?
Yeah,
If it was a detached garage, and that's a separate battle that Mr. Ryer and I have.
right, if it's a detached
Right,
garage,
We've had other cases along
Yeah.
that line.
yeah,
Right.
that's all I
tonight.
had, just
Thank you.
a comment for the board.
Dave?
No questions.
And regarding your earlier comment about my being chair and having all the answers, this is my probation year. I just wanted to make that clear.
I didn't mention having all the answers. I said you've been educated.
Got more than enough, so I'm not being chair again.
Is there anyone in the public that would like to speak to tonight's case? All right, hearing none, I'd like to make a motion, we close the public hearing.
Second?
All those in favor?
Aye.
Aye.
All right, case number 2023-07. I'm gonna correct myself, it's Paula. I'm sorry. M. Elroy, trustee of the Hatteroo Trust. Presented by Attorney Crowell, has been granted a special permit for the property located at 2 Andrews River Road, assessors map 16, parcel A1-B, in the RL zoning district, and the applicant seeks the special permit convert the garage to a habitable space in a non-conforming single-family dwelling. According to 325-52-54 and MGL 40A, section 6 and 10. Bear with me with my voice, would you please? As the proposed project will intensify one or more existing nonconformities, will not create any new nonconformity, and will not be substantially more detrimental to the neighborhood than the existing structures. All work shall be performed in accordance with the plans submitted with this application. There'll be no, let's see, we don't have to put anything down with regard to summer months. During the life of the project, all construction vehicles shall be parked on the property and not on a public street. A public street is your street.
And I don't know if it's public, but they also own property next door, so they
Yes,
could
he
park
meant-
there
Yeah, I
too.
didn't realize that, he said that, yeah.
So we're happy to do that as long as there's no time restriction.
Well,
All the construction's gonna be interior, right? Yeah.
it is a condition of this approval that a violation of the terms and conditions of the special permit may be enforced as a violation of the Howard zoning bylaw pursuant to MGL Chapter 48, Section 7, and the Howard zoning bylaw, as these may be amended from time to time.
Second, the motion?
Any further discussion by the board? Nope. Okay, all those in favor?
Aye.
Motion approved.
Thank you very much.
Thank you very much.
I was hoping for 8:30 tonight, but
too, when you saw it? You really thought you turned it?
You lucked out that the Round Cove case got, you lucked out that the Round Cove case got continued.
That's why I said thank you when
Yeah.
we first sat down. I know what's going on there, yeah.
Well, you have to thank attorney, who was it, couldn't make it.
Attorney
Singer.
Crowe, who was your doctor you had, do you need?
Yeah, the same one as previous.
Was it?
It was the same woman.
Dr. Leonard Remia
No, she could make it.
from
It was
Hyannis did a
the,
great job.
No,
Cape
it was
Cod
61,
Sports
that's
Medicine.
right, no, 61. That attorney for
My
61
wife is getting a
was the
hip.
attorney.
the one that couldn't make it was the attorney for the butter.
Oh, right, that's
By,
true.
by him?
I don't remember who it was.
Right, but the
Riley?
attorney that requested the continuance was before us.
Oh, yeah, she.
30 seconds.
She represents the,
Tell her to take, yes,
Wausau.
tell her to take the, they tell you what the drug regimen is.
Yes, yes.
You have to stay ahead of the pain.
Yes.
If you don't
She represents
feel
the
the pain,
closet,
it's too
but,
late.
yes.
You've gotta take the drugs in advance and stick to it.
I think it might have
That
been
works, and
Attorney
you have to
Riley,
do the
I forget
PT.
now.
Just gotta
I
push
picked up all
yourself
that
to the PT.
today.
So best
You
of luck
do,
to
you
her.
do need to stay ahead of the pain. If ever not. Must have been an interesting meeting last one.
What? Which one?
I just read the minutes. I didn't just read, I read them and it was sent to us, but the case, Bell's Neck Road,
Yeah. No, that went fine.
did it?
Yep.
Oh, okay.
Oh,
Fine.
okay.
Well, the town wants.
Yeah,
that to
I'll
happen.
address that in a second as well.
The town wants that to happen.
Oh, absolutely. But it sounds like there was some objections.
Yeah, there was plenty.
Yeah.
Okay, does anybody need to take a break? Okay.
Can I just ask a quick question while we're still up? As we were teaching before, the last case, the attached versus detached garage, what have we done in the past with regards to attached garage, but they're separated, right? Like there's a breezeway with a,
If it has an attachment, it's,
Yeah, we've taken a position if it's attached, it's attached, but that's a good point.
Yeah,
Because
no.
that was when the first one started, and we went on and on and on for hours, and finally the board decided, yes, even though it was a breezeway, it was attached, so we could take a position that was part of the structure, integral to the structure of the house. And you couldn't remove it without doing some damage to the house and a need for repair. So we said, yes, special permit.
the other question I have tonight, to go back to us putting a condition on the security fencing. I mean, is that really within our,
No.
I understand the reason why.
No.
But when we put a condition in that,
I was just trying to save them a headache.
see, is it saving? Cause I'm like, if they don't do it, then. they
No,
lose it.
we have
we
the
can
power
put
to do
that,
that.
on there.
no, we can put a condition on like
Yeah,
that.
we can put conditions on.
Was it
I mean-
the attractive nuisance
Yeah,
Right.
yeah,
approach?
If you look at
I
325,
understand why.
yeah.
I get it, but I just-
51,
our parameter.
board may attach such condition to a special permit deemed necessary to protect the public in a neighborhood such as, but not limited to, and then they go through. So, yeah, we certainly could require that for the safety of the public. That was Al's point. The poor drunks that are gonna go up there from the beach.
Well, there's been a lot of problems.
They're gonna fall off of it.
Yeah.
I don't wanna see them get sued.
Okay, I don't have them in front of me at the moment, but the minutes from the February 22nd meeting, thank you.
There's a copy right here.
Is that February 22nd?
Yeah,
Okay. Yeah, I got an extra somehow. I probably stole yours
Okay.
when you weren't looking.
is, anybody, did everyone read them, and are there any questions or comments regarding the minutes and for corrections?
A few minor typos, but
Yeah.
I don't think we need to worry about them.
Me either.
I had no substantive
I
comments.
mean, it was a,
You know, what I would like, though, to suggest is at some point you ask, oh gosh, I'm running out of gas here.
Alicia?
Jamie Goodwin, she's the person that does the videos, in charge of it.
Right.
How long they keep the videos, because our minutes are, bare bones, but the video has all of the comments,
I think it's
all of
30
the.
days.
Oh, no, they keep you can go back.
Yeah, it goes back years.
Yeah,
I think
Oh,
they're all,
maybe, how long can you go back?
indefinitely.
Oh, okay, perfect. That answers my question then.
when I've looked them up, I've gone back to to 2017.
Okay.
Yeah, it would be nice if
The
they
minutes are
actually
bare
had them
bones,
listed
but
in
as long
reverse
as
order.
we've got
of the most recent date, that you don't have to scroll all the way down from
is that right?
2017. I don't know if they could do that in the archives, but
Well, Frank's gonna want to get a copy of his first vote. Right.
If you just go onto YouTube and put the date, it'll bring it right to the,
yeah, but if you go to the town website, when you click
All right,
the
so I'd like to
link,
make a motion.
the oldest meeting first.
Go ahead.
I'd like to make a motion, we approve the minutes as written from February 22nd.
Second?
Aye.
All those in favor?
Aye.
Aye.
Okay, all right. I have a couple of new business items. Anybody have anything they want to bring up for new business?
Just, I looked like in 10 seconds on that proposed ADU
I'm gonna get it, that's under
bylaw.
old business.
Well, I think they would have to, that comment I made to the attorney, they would have to come back. Because if it doesn't meet,
No, they have to come back.
they'll have to come back. Where is it?
It's,
They don't comply with the setback or lot coverage requirements. They have to come.
but he
with-
said that the setbacks are fine. I didn't go back and look.
Well, but it also covers lot coverage. He said that wasn't fine.
Okay, all right, so,
That would require them to come back.
okay,
I thought so, but I couldn't find it.
yeah.
The only
I-
question I added, which I think is new or old business, I think when I was watching the video from last month, you had talked about perhaps having some training for the new members.
Yes, and I'm gonna start to address that. All right, so, on the new business, just real quick, the case we had regarding 5 Bell's Neck has, went through the 20-day period without having any appeal made. I only bring that up because early in the month, the attorney from the Butters had requested all the documentation on the decision, and as well as all the information to have, to serve the board on the appeal,
This is which one? Bell?
on the 5 Bell's Neck.
Those- Yeah.
Yes, and the appeal period was over on the 27th. So, John, every time anyone, as you know yourself, okay, but everyone anticipated an appeal to be made. Now, fortunately, I believe the fact, the board that night, and I know, Chris, you weren't here, I don't know about this one, but the board that night was very thorough in covering every possible contingency on looking at this whole case. I mean, we tore it apart, and then,
the attorney did a good job.
Attorney did an excellent job.
And we spent a lot of time.
Yeah, spent a lot of time, I
As a
see.
board.
Right, and Dave, he was the architect of the motion. All right, and before we, finalized that motion, we made sure we went through it, that we had, everything we had said that night was correctly put in writing. So I think the board did a good job that night in the follow-up on making sure that the written opinion motion was done and covered all the bases that were discussed that night. So I believe that perhaps what's helped this thing not to get appealed was because we thoroughly did our job. And
Hopefully, yeah.
Yeah, well, no, but, it didn't get appealed, everything was fine. I went back over it again, and just to make sure that we caught every aspect of the required of the code. And so it was a solid decision.
Yep.
And I think at that point, fortunately, I think it would have been upheld on appeal, but now, instead of having wait a full year to get that thing done, the owner can go forward with the
Right.
project.
Would have been probably 3-4 years. Yeah.
Oh, okay. So, old business on,
I have one more new business.
oh,
item.
sure.
I just thought of it.
Oh,
We
actually-
can't comment on the case, but case number, we can't comment on substantively on the case, but case number 2023-05, the Round Cove case, there is an article on, in last week's Chronicle, if you missed it, on this petition, when it went before the planning board. So if you haven't seen it, I could send it to you.
I have it, but if you can look it up, Dave can certainly send it to
Yeah,
you.
but it's worth reading.
Yeah, they interviewed a
Just for
lot of the
background.
neighbors in that article and all that too, didn't they?
Yeah, well, we can't discuss it, but just, I recommend you read it for background.
The, that's gonna be an interesting case. All right, regarding, I made some copies here, and going through and just noticing different, decisions that were published, or comments or reviews by different attorneys, et cetera. Just a handful of publications that were done to help on some of the,
Thank you.
some of the laws and so forth. And we're not going to go over it tonight. I just wanted, if you could, at your convenience, take a look at it. It just helped for me to help clarify different ways of viewing what we spend most of our time on here, non-conforming structures. And I think from time to time, you know, as I see something, or any of you see something that you think was interesting in how it approaches the review of non-conforming structures, and type of cases that we see before us, you know, please bring it and share it with the rest of the board members. So I had talked about that, and I think it, you know, particularly, at times when we have questions, we need to address each other, and of course, we will rely a lot on David's knowledge. Okay?
Dangerous, always dangerous.
All right, and we don't always agree with him, all right, but he does poke us in the side from time to time to make sure we're paying attention. But I do want to take a look at this. We can address things further next meeting if you have any questions, but, you know, I think there's hardly a meeting that something doesn't come up that we have to think about how we apply the code. And the more we appraise ourselves of other decisions, you know, I think it's gonna help us with confidence going forward in some of these
Yeah,
things.
and just along those lines, I apologize on the Atlantic, but we really sort of had a conundrum there because our town attorney said we could not vote a special permit where the road was infringed. And yeah, we did it with a condition, but she sort of had us boxed in there. That was the point I was trying to make, but.
No, but because of the point you made, we ended up, I think, on the long term, a far better situation removing that foundation wall, which the applicant realized was the best way of going, and
Yeah,
then,
they gotta move it, they gotta take it out.
and then it was pointed out regarding the sewer coming in at some point, that they're gonna wish, when that comes down the street, that they had done that. Okay?
One of I don't know if it was the attorney or the contractor, the potential contractor that was there, abandoned in place. Is that a legal thing? Could they
Well,
have done that, take it down a foot and abandoned in place, meaning they cede that to the city?
I don't know. I don't know the
But
answer.
they can't secede something to the city that isn't on their property.
Yeah, I mean, that's the problem, is how deep does your property go, right, to the core?
Well, it's not even their property.
You know,
They're
well,
saying-
and from the town's perspective, how deep does the
Yeah.
town own, right? But I think abandoned in place on a,
Core.
is a common construction practice if you,
Yeah.
depending on what you're doing, you know?
Well, I think they could maybe walk away, but if the town pursued them, they'd be liable, because they don't have any rights to leave it there, so they would be still a trespasser.
Yeah, I mean, for me, I mean, the more, and again, I was thinking about it more during the discussion, was, my guess is that sewer's gonna be aligned more towards their side of the street when they get there. And when that sewer contractor comes in and starts excavating close to their side, and maybe the foundation goes like this, the farther you get under the
Oh, yeah,
ground,
who knows?
it's a lot better for them just to get rid
Right.
of the damn thing.
And my concern was it might, under the condition, it still might fall through the cracks, but at least we're covered. You know what, we can say, hey, take the house down, take the porch down, and we will be.
I agree with their
court a whole.
original.
And that's why I wanted to get protection on the backside for maintenance. You know, I don't know how they're gonna do it for 1 foot if they don't reach an agreement with the neighbor.
Right.
And now they're either gonna do that, or, again, if they've trespass and the neighbor complains, we can tell them, okay, fine, take the back wall down, move it back 3 feet, see how you like that.
It may not be real common here, but that tilt-up type of approach, it's the maintenance that's a bigger issue. If you know, if your neighbor doesn't like you, you know, what you're gonna do with that type of stuff. But I know they made the point when I was watching the video from the previous meeting, is this whole thing probably arises from the changes in survey technology. Because, you know, .14.
Oh, probably, yeah,
It's just
survey,
wherever
yeah.
somebody, you know, back in the day with the chains and
Right.
the eyesight, you know, put a benchmark.
Yeah.
Now, you know,
And they might not have even-
is a laser doing it, and
Might not have even had a real survey.
I don't think the town ever
Well, no, when those places went in, those were back in the late 1800s.
yeah,
through
that's
the
what I'm saying.
early,
You know, back then, they surveyed with line sight and chains. You know, I mean, that,
The, last night, again on new business, I appeared in front of the planning board, and I spoke on behalf of the ADU. Now, the copy that you got was revised. So, this is the information
Oh.
that was,
Maybe I'm wrong then, maybe it's.
no, it's in there, it's in there. See, they just, so some of the revisions are on the front page, and then it's on the,
Yeah, it's still there, lot coverage requirement.
it is, it's a different number.
Setback
It
and lot
it used to be
coverage,
M and now it's K.
Yep.
Okay? So, I want to make a motion. Now, what I said last night at the meeting regarding the ADU amendment was that the Board of Appeal, the Harwich Board of Appeals had approved the original amendment with questions on the setbacks. And, you know, we want to, in fact, we want to change the setback requirements. So I had met with Paul, the Planning Community Development Director, and we hashed out over a period of a day or so, the wordage of item K, which is that the zoning board of appeals may grant a special permit for a pre-existing non-conforming principal dwellings and residential accessory buildings that do not comply with the setback or lot coverage requirements in the applicable zoning district. So I pretty much wrote that out for him, and he approved it and included it in the amendment. All right, but we did that over a couple of days. So what I said last night at the meeting, when I said that at this meeting tonight, the Board of Appeals would vote, you know, on the approval of the amendment as written. Because they're gonna want me to either appear at town meeting or write a letter for town meeting showing the zoning board's approval, you know, of the amendment. So I'd like to make a motion that the board look at this amendment and vote that we accept it as written, and we approve it as written. So if you might take just a quick minute, I mean, I think you might have read it already. There's only a couple of changes what you saw before, and they were more structural in the amendment rather than additional information. It's still, in this particular amendment, is dropping it down to no square footage requirement. But when I met with Paul and discussed with the planning board at last month's meeting, I pointed out that cutting it down to square footage wasn't gonna gain you much at all, because so many homes in town that were particularly, you know, well under 40,000 square feet often had setback issues. So if they're going to achieve the goals of the ADU, they need to put it back in the hands on non-conforming lots, you know, for the Board of Appeals, which the planning board agreed. And last night, my presentation, I just discussed the fact of the people who have come in front of us with ADUs have been because of thinking they could get it approved under hardship, which doesn't happen, because of it's a, and as the attorney pointed out, because the use is changing, and that's creating a new nonconformity. So we can't approve it, okay? But because the variance on financial hardship is in there, I think people, run to that, as thinking they can get it accomplished. So, would like to make a motion that we approve the ADU amendment as written?
Let's say as written, dated March 28, 2023, in case there's a further amendment or something.
Okay.
Let's tie it to this one.
So I'd like to make a motion that the board approve. And before I do this, there may be some possible technical changes in the amendment that they're thinking over, the board. And I think, what was discussed last night? The requirement for sewer.
Right.
The current thing requires anyone who has sewer,
You must hook up.
they must hook up. That may get, they're gonna probably put it forward. They'll probably put it forward at town meeting, and if approved that way, the Attorney General's office may shoot it down. But they figure it's gonna be a line item shot down, not shutting down, not canceling out the whole amendment.
Why would it be shot down? What's wrong with putting that?
Because the average homeowner is not, if you get, sewer goes in front of your street,
It's within the purview of the Board of the Health. So they're gonna try to get it's in the cover sheet here, it's explained in paragraph 4. They're trying to get the Board of Health to incorporate that requirements also.
but it's not
The AG
required right now.
might say it's none of the zoning board's business, essentially, that's a Board of Health
So
issue.
it's just not our business.
No, it's not, but it could possibly change the fact that the sewer requirement goes up. More than likely, it's gonna go to town meeting with a sewer requirement in there. So, but that could possibly change, as they politically size up how to handle it. But the feeling was last night that it would be a line item adjustment by the Attorney General's office, not eliminating the whole amendment.
That whole thing is very fluid.
Yeah,
Extremely
sewage
fluid.
usually is. I'm connected, by the way.
Yeah, but you weren't required to connect, you chose to connect.
Well, within 2 years, I had 2 years to do it.
Define connected, would you please? Never mind, don't go there.
So anyways, other than that, so my motion is that.
Can I just
essentially-
ask a clarification question before
Sure.
the motion? So with the revisions, it looks like, where it says if the addition of the principal dwellings be constructed, the addition shall comply with all setback requirements. But then later, it basically says the Board of Appeals can grant a special permit for pre-existing non-conforming principal dwellings.
Right,
So are they basically saying if you're not already non-conforming,
Can't create it.
you can't create a non-conformity in
Correct.
building an ADU? And
that's correct.
that sort of overrides the lot size, right? So irrespective of, because I think that's really gonna restrict the number of people that are gonna build ADUs,
No,
right? Unless you're on a huge lot, right?
No, the lot size being brought down to 0,
Right,
okay? But for people who have conforming lots,
right,
they're required to maintain the setbacks in their zoning code,
right. So they
By-
can't
by the
create
zoning
a
district.
yeah,
okay?
You just can't squeeze something in the corner.
right.
Okay. What we have added, like in our regular zoning codes, the people who have 40,000 square foot lots,
Right.
they can't encroach upon the 20 and 25-foot setbacks, let's say.
But I guess my
So,
question is, what
so
if
then when
someone,
it comes into, if you're non-conforming, which now gets into the, whatever cases, currently non-conforming lots can now come in front of the Board of Appeals to get a special permit for an ADU.
Right, the bottom line is that before this change, if they didn't conform to the site coverage or anything, they needed a variance, and no one likely could meet
Right.
that requirement. So now it's a special permit, which is a much easier
Right.
requirement
so
to.
I guess, I'm still getting used to the terminology like non-conforming. If someone has, say, a 30,000 square foot lot, right? But none of the setbacks are non-conforming, it's only the lot size that's non-conforming. Could they still come?
Sure.
Well, actually, no, they don't have to.
They
They're
might
gonna-
not
no,
have to.
they're gonna get
Well,
approved.
if they're now gonna be, say, they go from a 25-foot setback to a 15 with their proposed thing, you know,
They couldn't do that.
They can't do that.
They can't get a special permit in
Because
that
they're
case.
conforming.
right, well, I'm saying they're not gonna, if they're a 30,000-foot lot and a
If they're
40,000-foot
30,000 no, no,
zoning,
see,
they're
the new
already a
zoning
non-conforming
reg-
lot size.
This is a great question, okay?
You know,
But
The
you can't create
ADU,
a new nonconformance, which would, what you'd
So
be
the
doing,
set-off would be a new
a
non-conforming.
new nonconformance.
The lot size is
Isn't
one
existing.
conform, non-conforming, okay, so that's,
so if they're currently sitting at 19 and a half feet,
Right.
when 20 is required,
Right.
it's non-conforming,
right.
all right? It's a non-conforming setback. If anyone, you know, now, you can get an ADU if you're 20,000 square feet on a lot, but it requires you to have conforming setbacks as if you were sitting on a 40,000 square foot lot.
Yep.
So with Article K here, that means anyone on a pre-existing non-conforming lot, which if there's an RM1, which it requires 40,000 square feet, and they've only got 13,000 square feet, like 10 Kings Road,
Right.
they can come before us. Okay? Okay, so, just to restate the motion, requesting the Board of Appeals agree with and approve the accessory apartment bylaw amendment changes dated March 28th, 2023, as written by the planning board.
I'll second that motion.
All those in favor?
Aye.
Aye. Motion approved. Okay. Does, one last thing, let me just pull it out. I should have done this under new, I'm gonna send out, first of all, I'm out of town next week, so I just mentioned, when the decisions are written by Alicia, I'll be on Monday, but she won't get them done. I'm gonna have Al go in and sign the decisions. I'm not back till the Wednesday after Easter. Okay. Now, I'm gonna be sending out by tomorrow, well, by Monday, just some additional background information regarding 40Bs. And some of you already got the material, I'm just gonna update it and send out 40B information to everybody regarding how the process works. There's a 60-odd page document regarding the whole process that's available from the state. But I'll be sending those links out to everybody in those PDFs, okay? I'm assuming everybody can get those on their computer. If you should want a printed out version of it, let me know, and at some point I'll get up to town hall and I'll print one out, but if you could, for right now, use your laptop and so, that'd be great.
So you're gonna be sending them a lot of links that you just said?
I'm gonna send links on the 40B information.
Can you add one more link? There was a link that came out a long time ago on a meeting, it was a training meeting held by an attorney on the whole 40B process. I believe it's a YouTube video. If
I
you
don't
can
know.
find that, I mean, I'll dig it up if you can't, but. if
Oh,
you're-
Renee Quazell came to give the talk here?
Yeah,
Yes.
and I didn't get to it, I don't remember where I was.
I'm sure they're still on, to be in a meeting.
Did we tape that?
Yeah, it was,
Yeah.
that's exactly what I wanted
Okay.
to see, is I wanted to see that video.
Yeah.
There was no video, it was all verbal. I don't think, we didn't have a
But
camera on that night.
well, there's a
No,
video
I
of
thought they
whatever's
videoed it.
presented.
Do they,
Remember, I had to put it on, and I
Okay.
had not put it
Yeah, there
on,
was a
I
video.
called up.
I mean, there may not be anyone's face in it, but the slide is there and the voice is there,
sure.
like watching a PowerPoint slide presentation. But I'd like to go over that before any 40B comes up. I haven't had a chance to do
The
that.
other thing, you really should link to the regulations. They really have a lot more info than any of that other stuff that we have to comply with, the regulations.
Yeah, so I'll send out what I think is appropriate. Anyone that finds additional information they think is appropriate or useful, I mean, pass it on, okay?
Well, if you
Now-
can't find it, it was in an email, a text, probably an email, and I'll see if I can dig it up.
Okay,
I'll look through, I probably have a note on when she came someplace, or in my calendar.
Yeah, if you have a date, that'll
Yeah,
make it easier.
once
to
I
dig
get
it
the
up on
date,
the
we can
computer.
find it. I'm sure it's in my calendar.
now, I bring this up for obvious reasons, okay? And and I believe I can discuss this briefly, this is regarding Chloe's Pass. Now, recently, any hurdles that I thought were key hurdles that in my opinion, we're preventing them, or they're waiting on to get passed before they submitted their comprehensive permit application. So that's the next step to the Board of Appeals. So the CPA, we have not seen it yet, but I believe they've held back on submitting a CPA, comprehensive permit application, because they wanted to address all the key, particularly environmental hurdles.
Turtle and other things like that.
Right. So the NHESP, or the National Heritage Endangered Species Program, whatever, but the State Environmental Commission that oversees that gave them an approval for what plans they have, or how they're going to address environmental concerns, particularly the endangered species being the turtle. And recently, they also had, that's also considered a MESA, it's called MESA, which is a Massachusetts Environmental Species Act. So they passed all the requirements of the MESA Act, as far as they're concerned, and they were given when they passed they approved the plan, how they're gonna address environmentally, and particularly the turtles. And last week, the Conservation Commission in Harwich also gave them an approval. So, other than, there was an open item regarding how they're going to revise the road, or whatever it might be. Those are all structural issues but I think the major hurdles that I thought that they needed to address, I don't know I think they got a clear path now, as far as not to be delayed, on now focusing on the CPA and the Board of Appeals. Now, I could be wrong, but I just want to point that out.
And I think, I agree that those obstacles were big ones, and if
Right.
they got over those,
So
they go through the process.
that's already been reviewed and approved. So the state has approved the plan on the environmental issues that they had there. Oh, actually, excuse me, on the endangered species. Now, during the CPA, other environmental issues can come up. So the environmental isn't done regarding, water or wetlands or anything like that. It's the endangered species situation which has been taken care of, as I understand it. And I did have to confirm with the Conservation Commission. Okay. So, basically, I expect at some point here, we may be seeing an application coming forward. So I just want to now, I want to emphasize that, every case we have sometimes has a lot of interested parties that may be upset over how things happen. One of them occurred tonight, but this particular case, it involves a bigger neighborhood and a bigger area. I just want to point out the fact that we cannot discuss this case outside of a meeting, as far as the specifics of the case, and particularly, you're going to be, as you're on the board, you're going to have people that, particularly you may live in that area, that are going to, may hit you up and ask you questions or give you comments and so forth. Just stay away from it, all right? I've been emailed by residents already regarding this case, and I referred over to our town attorney, and I sent back an email to people saying, here's why I cannot discuss this, and please don't email me again on this matter. So if you do get an email from someone, please forward just to me the email, and then email back to the person, not to be disrespectful, but I cannot comment outside of a meeting regarding this case. And please don't email me or pass my email address on to other parties. Because this will be an interesting process. Dave's been through 40Bs before. I think this is probably one of the larger ones that you've
Well,
dealt with.
we've never had one like this in town.
Right.
This is gonna be all new to everybody, really.
You do waste treatment stuff?
What's that?
Did you guys do waste treatment plants?
Early in my
facilities?
career, Blue Plains in Washington DC,
Oh,
biggest one in the country.
you know, this was, the one in Truro was held up because of, and waste, you get a lot of people, big unit, how are you gonna handle the waste? And the one in Truro was held up, that was one of the big issues.
I mean, there's a lot of these things that, to me, you get from and even for me as, you know, the property I own, there's got to be a convergence on the sewer plan of tying it into these programs, because, you know, what the state's requiring for water quality, you know, which is appropriate, you know, to make someone potentially spend a couple $100,000 on their property because their septic failed, for 3 years later to have a sewer line on their street, there's got to be some happy medium that says, you know.
Well, let's save that for the case. I'm gonna move to adjourn the meeting before I
Yeah,
fall
so,
asleep here.
Yeah, I just, but I appreciate, just want to bring that all up, get you guys up to speed, and it could happen any time. If it does, we need to get moving on CPA. So, Dave,
I second that motion.
all those in favor?
Aye.